Are we ready to continue? Yes, claimant and respondent.
I think people might be trickling in, but we're happy to start, Madam President.
Okay, then we hand over to the claimant for cross-examination.
Thank you, Madam President. I'm going to turn to Spanish. Buenas tardes.
Good afternoon, Mr. Bravo, Mr. Picon. I don't know if you recall me. My name is Laura Sinisterra, and I represent claimant in this case. I will be asking you some questions just to remind you two very important rules. First, today is the last day for cross-examination. We don't have much time. I apologize ahead of time, but if you don't answer briefly and precisely, I need to interrupt you because simply we do not have the time. Your attorneys will have the time to ask you additional questions. So if you want more context, more details, you're in the hands of your attorneys, but I need to be quite strict and have brief answers. You only one can answer. When the tribunal asked you questions, both of you answered, you supplemented the answer. Those were the questions by the tribunal. But the rules say that when I am asking you questions, it is one person, the one who responds, okay? Agreed. Do you have your folders?
To add to one's response,
They need
can
leave from the
request
tribunal.
leave from the tribunal.
Correct. Bueno.
We're going to start with an extremely basic question. We're going to start with an extremely basic question. I asked you this question during the hearing of Sumitomo in February. Your presentation, the one you gave us today, says
My apologies. I will. A second.
No need to apologize. We apologize for the large binders.
So, sorry. Please go ahead.
Thank you, Madam.
in your presentation today, you introduced yourselves as experts on tax law. Your reports, as we can see, the cover page also says experts in tax law. But you also have several sections in which you analyze the general mining law and also opine on the scope of a stability contract in the mining sector. Are you experts on mining law? We're not experts in mining law. But in spite of that, you have two sections in your reports opining exclusively on the scope of a mining stability contract. As we said in the previous session, we are experts on the application of the mining law, and often cases we have seen legal stability cases, tax stability cases, and hydrocarbons stability cases. And mining too, well, those are the second category, tax. Tax stability is for mining. So it is valid to ask you about mining, tax mining law, correct? We're not specialists in mining law, but I imagine you can ask the questions. I just wanted to clarify for the record that you're not specialists in mining tax law. I don't know if you recall, but in February, I explained to you that the date when the regime was stabilized, that is to say the tax regime applied, is relevant. It is important because it determines the provisions that apply based on your stabilized regime. Do you recall that discussion? Yes. In February, and here we have the transcript, it was clear that there was a small confusion and you contradicted yourselves. And finally, it seems you said that it is the date is the relevant date to determine when that stabilized system was fixed. That is the date of the contract, and that is what you say in your report. But at that hearing, I showed you that 9.5 under the contract, the General Mining Law, Article 85, and also the regulations state the opposite. It says that the relevant date to determine The regime that was stabilized under the contract is the date of approval of the feasibility study of 1996, and then in February you said that indeed that was the case. It is black and white in the contract. My question is, why is it that you didn't correct that in this report? Why don't you tell the tribunal, you know what, I need to introduce a correction because my reports say that the relevant date and the date that I considered is the date of the contract, but the contract and the law state that it is the date of approval of the feasibility study. Did you consider that there were mistakes that were not important to correct, or why is it that you did not correct your report? Because in February we established that there was a mistake. I think that you misinterpreted what you're saying, because our reports at 12 and 21 indicate the date for stability. Indeed, given the mechanics, our system in which we work, there was a problem, a communication problem, but the reports are quite clear. Just to clarify, there are 3 relevant dates. My question was very clear. So you consider that there is no mistake in your reports. For example, at paragraph 196, it says at the date of the signing of the agreement, February 1998, the provision to be applied was, for example, IGV of the decree, and then it was not stabilized. We're not going to discuss this. We can all watch the video, read the transcript, but at that hearing you recognize that maybe there was a clarification we needed. So you thought it was not important to include that here. As I mentioned before, at 2 and 21 we state the date of the feasibility study. Yes, but there are other paragraphs that state the opposite, and you are not correct in those paragraphs. Let me help you, and we are going to look at this on the screen. You reviewed your report, and did you make sure that there are no other mistakes that need to be corrected? Is that a generic question, or are you speaking about something in particular? In my opinion, there is a clear mistake. In February, you recognize that. So I want to know, did you review your reports, and are you certain that there are no other mistakes? Did you review, and are you certain that there are no other mistakes? Yes or no? The mistakes you found were corrected in the second report, such as the IGV provision. Did you correct all of the mistakes? Yes, before the hearing. Let us talk again about the hearing. During the hearing, I asked you about the feasibility study. You told me, and here I am citing what you said, that the detail of the feasibility study was not relevant. The detail of the feasibility study was not relevant for the conclusions you reached. Would you please show me? Yes, this is at tab 3. This is my question to you. What page? 2554 in Spanish. Tab 3, page 2554. Line 20. Here it says, the question is very easy then. I will be reading this to you. I asked you, do you assert that the scope of the contract is defined by the feasibility study? And then my question is, did you review the feasibility study to define the scope? Yes or no? And this was your answer. We reviewed all of the information that we had been given, including the feasibility study. But, and my question is going to be about this part of the answer, but the study was not relevant to our conclusions. Do you see that? Yes. Do you maintain that the study was not relevant. The feasibility study has 223 pages, and the last 73 pages include graphs and pictures, and we are talking about the study in detail. We were referring to a large amount of information that was not going to change our opinion. What parts then were relevant to you? What did you review to share your opinion about the scope of the stability contract? The feasibility study was reviewed completely. My question is specific. What portion? You need to space and you need to slow down. I understand that your position is that not everything is relevant and the graphs, I understand all of that, but what portion, what part of that feasibility study was reviewed, was relevant to reach the conclusions in your report in connection with the scope of the contract and make sure that the concentrator was not covered? What is it that you reviewed? My colleague will be addressing this. Thank you. The portion that we reviewed is not technical and engineering part that as lawyers we do not understand. But all in all, we saw the purpose of the investment plan. What is it that was presented for approval as an investment plan? And what is it that the General Mining Office or General Mining Directorate later on approves? This is what we are referring to when Mr. Picon indicates that it was not relevant to determine the detail. He is referring to the technical portion, not the object of the plan. This is what I wanted to say. The technical portion may be important, so my colleague is sharing with you the feasibility study. You are saying that you read it, you are citing this in your report, you are saying that it is important. Would you tell me what is it that you reviewed and what you think is relevant to reach your conclusions? I just want to know what portion. You don't need to describe it or sum it up. What portion? To begin with, 1.1, 1.2, the executive summary, is that something that we reviewed too at 1, 2, 2.2, 2.3. How can you be certain that this feasibility study does not refer to the concentrator or nothing related to the concentrator if you just reviewed the executive summary, some pages, and you don't seem to be familiar with this document? Well, this is a cross-examination. We don't have much time. We're giving a document that we did review. It is long. Yes, we did review. Some issues we do not understand. They are of a technical nature, but clearly with the review of the document, the plan proposed to be approved is the one that does not include the concentrator, but only the leaching. Let us explore what you just said. That at any rate, I think you said it is evident or it is clear that it was for the leaching project rather than the concentrator. That is what you told us. You are saying something similar in your report when you're analyzing the scope, and you conclude that it did not cover the concentrator, but let me tell you that I read every detail extremely carefully, both of your reports from beginning to end, and honestly, it is not completely clear what your position is. It is not clear what your specific position is as to experts and the scope of the stability contracts under the general mining law and the regulations. So let me ask you something very specific. I will be facilitating this for you. I thought that you were saying one of four things upon reading your reports, and I am going to read to you. I think we gave you English and Spanish. These are the 4 potential positions that I think would be viable from your report.
Could you tell us the paragraph numbers and report numbers and where you got these?
1 second. I will specifically point them to specific sort of paragraphs in the reports, but here I'm not citing to the reports. I'm just asking generally what's their position.
What is the source of this information on the slide?
Well, it's mostly based on paragraph 35 of the report, but I'm not asking them about the report specifically. I'm asking a general question. I just want to know what their understanding generally is about the mining law.
So this slide is not from their reports?
No.
Okay.
Señores Bravo y Picón, de nuevo, para entender.
So once again, to understand you are here appearing as experts. You have shared your opinion as experts, mining tax experts on the scope of the stability contract, and you are saying that it did not cover the concentrator. And I said your opinion is not clear, and I would like to understand it because you are the experts that Peru called for on this issue. I would like to know, based on your expert opinion, what your position is given the general mining law and the scope of a stability agreement. I would like to ask you about 4 possibilities. Possibility number 1. Possibility number 1. Stability agreements under the general mining law only cover the specific amount in the investment program included in the feasibility study. That is, the amount of the investment program. That is possibility number 1. Possibility number 2. Stability agreements also cover not only the amount in the program, but any replacement of the assets listed in the investment program. That includes the replacement of the assets listed in the investment program. Possibility number 3. Stability agreements or the general mining law cover all of the investments related to the investment project included in the feasibility study. Or possibility number 4, what investments are covered by stability agreement depending on various factors and must be decided on a case-by-case basis. And so, as experts, which of those 4 is your position, or is there a 5th one? And in that case, which one is it?
Experts in mining law, and they've clarified they're not specialists in this, so they can give you their view from a tax expert perspective.
Two entire sections of the report are about the scope of stability agreements, and they interpret the mining law. So I'm happy for
From
them.
the perspective of tax experts, yes.
Fine. From a perspective of tax experts, they are the experts you have presented on this case, on the scope of the stability agreement.
Disculpe, ¿va a mostrarnos dónde está citado esto en nuestros informes?
Are you going to show us where this is cited in our reports? I am not saying that this is cited. I just want to understand your opinion as an expert. So the scope of the contract, that is, under the general mining law, what is the right position? What is it that the stability contracts cover and they do not cover? This is your opinion, position 1, 2, 3, or 4? Our position is that this is included in the stability contract, that is to say, the investment made, and that it is described as part of the stability contract or agreement. As we said, this is a contrato ley. That is, whatever the contract says is to be applied. Yes. But what does it mean in practice? I saw that in the report. Are you describing positions 1 or 3? Let me read what you are saying to be able to answer. Here you are saying that the contract only covers the specific amount in the investment, but then it says in number 3, all investments related to the investment project included in the feasibility study. Because what is the difference in your opinion? Because one has to do with the specific amount and the other one with the concepts. This is I thought it was a simple question. A mining company presents an investment plan for $100 million, and according to the general mining law and according to your understanding, that contract would only cover those 100 million, the 100 million, but if that did not include many assets, for example, are those assets replaced, or is there a new technology and a better asset was bought? It is a replacement and improvement of the assets under the investment program project. Is that covered, or whether new investments are made but they are linked to that project, to that investment project? In the case of Cerro Verde has new investments linked, related to the leaching project. Are they covered? Or once again, we need to analyze this on a case-by-case basis because there are several factors to consider. When we look at position number 4, and you said that we need to analyze case by case, we need to analyze the contents of the agreement. It is a hypothetical case, as the one you are saying. Well, let's bring it back to Cerro Verde. In the case of Cerro Verde, you said that you read the contract and that you read the feasibility study. In the case of Cerro Verde, which of these 4 positions is the one that you are presenting the tribunal? Which one is the right one? The contract is referring to the leaching process project. Yes, and you say that in the report, but I want to know what it means in practice. The leaching project includes new investments related to the leaching project, or does it only include 237 million as reflected in the investment program? What is your opinion? In principle and strictly, as we said before, the method to interpret the agreement has to be restricted and literal. Please let me know. I think that you are tax experts. I'm asking you something valid. I would like to understand. I would like to understand what your position is so that we can have a conversation today. I'm asking you, be specific, because you were not in your reports. Be specific. I want to understand your position. Only the amount, only the 237 million, or new investments but related to the leaching project? Would they be included because it is the same project, or do we need to understand this investment by investment, or is it a replacement of the assets listed there? I would like to understand your position. Is it 1, 2, 3, or 4? Please be specific. The literal interpretation is the one that would lead us to say that it is a project and any investment would have to be analyzed. So that means that it is 1, 2, 3, or 4. That it is case by case. It is not a difficult question. You have opined on this topic. I see you confused, and I want you to answer my question. Be specific. Which of the 4 positions is your position as an expert? As drafted here, I would say number 3. Investments related to the investment project that is included in the feasibility study. So position number 3. Understood? 3 individuals have said that. And so position number 1 is wrong according to you. That is, that it is only the 237 million. That is not correct in your opinion, because you just told us that position 3 is the one that is correct. Investments related to the investment project related included in the feasibility study seems reasonable according to the law, but if you have a specific case, clearly we can analyze it. We are talking about Cerro Verde, and I would like to confirm that, and this is also similar to what you said in your reports. Your position is position 3. Yes. And the other positions, again, I imagine you confirm that your position is 3 and you do not agree with the other ones. But they are excluding positions. You already told me that your position is number 3. If you want, we can continue, but just to confirm, it's 3 and not the other ones. 3 and not the others. Unfortunately, I need to clarify, when one looks at tax issues, we look at the timeline, the subject matter. We have a million possibilities, and when you have a case, you have to compare against another case, but in the case of Cerro Verde, it is number 3. Yes, it is. And I understand that regarding tax issues, there are a million possibilities and a high number of cases, but we're talking about a law and some specific articles, so it shouldn't be that difficult. But position number 3, understood. Thank you for clarifying your position. Now, the other party asked me to, opposing party asked me to explain whether there was support in the record for the other assumptions I was representing to you. And I would like to share with you that this week we heard these 4 positions from various witnesses, including Peru's counsel. Ms. Bedoya told us that it was position number 1. Mr. Polo told us it was number 2. Peru's memorial says it is number 3, that at least coincides with you, and Mr. Cruz told us it was number 4. But even Peru, in their own witnesses, we're not even talking about all of the documents and all of the evidence presented by claimant, but just
Reports.
The report is about the scope of the stability agreement.
The report is not about the scope of the stability agreement. The report goes into issues with respect to tax. That's the main essence of their report. You keep on mischaracterizing that. It's not appropriate.
I mean, the fact that I have to take you to the report to show what they've analyzed and that we saw it on the slides this morning. I mean, you're impeaching your own experts, which I just find a little puzzling, but I'm very happy to refer you to the sections of the reports that I am basing this on. So section 3 of the first report is called El Contrato de Estabilidad.
the stability contract of Cerro Verde did not cover the concentrator. Y
Contrato
los contratos de estabilidad, los contratos de estabilidad minera,
concreto.
and also specific analysis, the object of the contract, of the stability contract.
Mañana nos hicieron una presentación.
They made a presentation about this.
The primary sulfide project.
Disculpe, cuando cambia de idioma tiene que dejar una pausa para que los intérpretes puedan cambiar el canal.
Okay.
Gracias.
Yes, we can all read what is in their reports. And it's clear that they've said what their specialty is, what their expertise is, and this perspective that they're giving as tax experts on these issues.
Are you saying that we can we go back to the report, please? To the report. Are you saying that we can strike from the record the sections of the report that refer to the mining law and that analyze the stability agreement with reference to provisions exclusively in the mining law?
No, I'm not.
Okay,
I'm saying
then
that they can analyze that as experts in the application under taxes of those laws.
Okay, so then they can answer based on their understanding just on taxes.
The
but they
question
have
is not the scope of their knowledge here, it's that this is outside the scope of their expert reports. These questions, this table.
I think I agree. I mean, and it does not appear too helpful for us if the experts now comment on the testimony and witness statements that we have heard the last days.
So I'm not going to ask them to comment on the different positions. I just wanted to understand what their position is because they have submitted an expert report on the scope of the stability agreement and they have opined as experts that it excluded the concentrator, and they say in the report the stability agreement was limited to the project, to the leaching project, and I'm trying to understand what that means. They have now specified what it is that they mean, and I'm just showing them that others have interpreted the mining law differently, but we do not need to go into a detailed discussion of what other sort of witnesses
Yeah,
have
would be
said.
appreciated. We take note of your argument, but I think we're here to hear the experts.
Yeah. Yeah, though I do think it's fair, Madam President, with all due respect, to confront their tax experts on the scope of the stability agreement with inconsistent positions that we've heard in the hearing to try and clarify ultimately what position is it that we're sort of being confronted with when it comes to the right reading of the mining law. But let me ask my next question.
Gentlemen, Mrs. Picon and Bravo, I asked you your opinion. I showed you that we have heard different opinions. In our view, we have heard and we have been presented with different interpretations. And so we have been presented with what in our view, well, we are categorically in disagreement with those positions, to be clear, but we have been presented at least what appear to be different interpretations of a single law. So the question I wish to put to you is related to tab 10. If you could please turn to tab 10. For the record, this is CE 823. Indeed, the tribunal put questions to you about this document. We are looking here once again. For the record, CE 823 is the statement of purpose of the law that incorporated 83B into the law on mining in 2014. I'm going to read a paragraph to you, and then I'm going to show you the Supreme Decree that was amended by the regulation, and then I'm going to put a question to you. So here, okay, I'll slow down. I wanted to take you to page 11. You can also see it up on the screen. And I want us to take a look at exactly what the legislators said. They said, the effect of the various proposed changes to the general mining law will make it possible to establish a clearer regulatory framework in accordance with the principle of legal certainty in favor of the investor. That is what is there textually. And now I'm going to I'll be putting my question to you in just a second. I'd ask you to first please turn to tab 11. For the record, this is CA 246, page 9. And this is the Supreme Decree that modified the regulation of the general law on mining in 2019. It'll be up on the screen in just a second. Point 1 under issues says the literalness. This is at tab 11, sorry. Tab 11. Do you have it? Very well. At B1, it says the literal reading of the text, or the literalness of the text of the first paragraph of Article 22 could misleadingly lead one to consider that the contractual guarantees benefit the owner of the mining activity for any investment it makes in the concessions or economic administrative units. And if you then turn to page 10, at C6, it's page 10.6. Yeah, we have it. It says, this is a Supreme Decree of 2019 that amended the regulation of the general law on mining, and it reads, this amendment will contribute to clarifying what emerges from the rules contained in the single unified text of the general law on mining and its regulations. And so we just saw expressly that the law and the decree used the words to establish a clearer framework, and they used the words juridical security or legal certainty, and they used the word clarify. And we saw that different witnesses have provided us with different interpretations, and interpretations that vary with your own or are different from your own views as experts. So my very specific question, please be honest in your response, at a minimum, are we not looking at a provision that might be subject to different interpretations, and which therefore, therefore a clearer framework is needed, greater legal certainty is needed, and clarification is needed? Yes or no? Is this based on what I've showed you and the different interpretations we've been given and the statement of purpose, in your opinion, are these provisions that might be subject or could be subject to different interpretations and therefore need to be clarified, yes or no? The interpretations that you've showed us did not reach different conclusions in the specific case, to be quite sincere. Yes, but could you answer my question? As we were saying when asked by the arbitrator, the amendment of a legal provision cannot be used to interpret the past. No, Mr. Picon, please don't go off on a tangent. My question is very specific. Did the legislator, in a decree, well, they are saying that they're going to amend it because there's a need to establish a clear framework. There's a need for legal certainty. There's a need for clarification. If one clarifies, it's because there's a provision that is ambiguous or imprecise and requires clarification, correct? Not necessarily. Doesn't one clarify? One clarifies what's already clear. One clarifies in the face of new situations. There was legislation for years, and the adjustments to legislative provisions, which are made every year, aren't always because, well, the provision was obscure, but rather we're always thinking about taxpayers of the future so that they not have potential doubts that some might have or have said they have. But I don't think that's enough to reach the conclusion that the provision was obscure, if that's what you say. So you are saying clarification is with respect to new issues, and here this law and this decree are clarifying provisions that already existed in the general law on mining and the regulations, and to do so they're using the words, there's a need to establish a clear framework, there's a need for greater legal certainty, there's a need to clarify. So my question is quite basic. You're here as experts. Here, the Peruvian legislator, is he not telling us that they want to clarify a provision because the provision wasn't clear, correct? To characterize this as the position of the Peruvian legislator, well, these are drafts that are or bills presented by the executive, and they are then presented to the Congress, and Congress debates them. That's how it's been done thus far. So your opinion is that in the Supreme Decree, when they said that Article 22 could mistakenly lead to one to consider that contractual guarantees benefit the mining title holder for any investment carried out in the concessions, economic administrative units, when it recognizes that it could lead to such an interpretation, and then it says clarify. You're saying your position as an expert is that they were not clarifying? Well, let's see. These statements of purpose, and these have been done for many years, do not have as their aim to being the key document for interpreting the provision in the future. Mr. Picon, if you don't want to answer my question, no problem. Let's continue looking at other documents. Fine. So to recapitulate, I've showed you what the witnesses have said. I've showed you what the Peruvian legislator has said with respect to these provisions. I've highlighted 3 or 4 times that they use the word clarify. Now, if you maintain that there was nothing to clarify, then let us take a look at it. Perhaps the SUNAT and were the SUNAT and the fiscal and the tax tribunal consistent in their application of the provisions? Let's see.
For the record, I am going to refer to protected information. Por favor.
Yes, that is well noted. We don't have any representatives in the hearing room or in the virtual hearing room, so you can proceed.
Quiero poner.
I would like to put up on the screen this paragraph 153 of your first report, or 123, paragraph 123 of your first report, please. This is your report, and these are your words. Specifically, Article 83 of the mining law and Article 22 of the regulation of the mining law were clear. So we saw that the legislator said there was a need to clarify them, but you said that they're clear. So much so that the tax administration of the government always maintained the same interpretation. Do you see that?
No,
Yes. Okay, I was just waiting for the interpretation. Recently, in this case, document was introduced relating to the companies Milpo, Yanacocha, Tintaya. These are SUNAT rulings and tax tribunal rulings. Did your attorneys provide you with those documents? Yes. Did you review them? Yes. And do you maintain your opinion that both the tax administration and the government always maintain the same interpretation? Clearly, we've not only reviewed the rulings, we've looked at what they're about, and we've reached the conclusion that they're not relevant. So do you maintain this assertion that they've always maintained the same interpretation, yes or no? As far as we know, yes. Based on the new documents that you reviewed, do they maintain it or not? The antecedents don't go to the issue. I don't know what you're referring to. Oh, the rulings of the SUNAT regarding Milpo, Yanacocha, and so forth. We've reviewed them, and they don't touch on the issues that are present in this arbitration. Well, but they are rulings of the SUNAT and the tax tribunal. You've reviewed them, and you continue to maintain that that's always been the interpretation. We don't know any pronouncement different from these. So you maintain your position, having reviewed this and this background. Yes, we maintain our position. I told you this at the outset, but I want to be very clear. Unfortunately, we have very little time. And so I would be delighted to review in detail all of these documents with you. But because of time considerations, I can't do so. So I'm going to show you certain documents and certain statements by SUNAT and the tax tribunal. And if your lawyers would like to go back to those documents and get into more detail and discussion of factual issues, then they're free to do so on the redirect. But I am going to ask you specific questions about things that you're going to see on the screen. And once again, you'll have an opportunity to discuss it in greater detail. I'd be delighted for you to do so. The first document that we're going to see for the record is CE 1154. It's a determination resolution of the company, the mining company Milpo from 2005. Do you see it on the screen? Yes. There, the SUNAT said the El Porvenir mining unit has a tax stability agreement. The El Porvenir mining unit. It doesn't say the Milpo project. It doesn't say the El Porvenir project. It says the El Porvenir mining unit. And now let's look at another document.
28. También es una
It's also a determination ruling by in respect of Milpo from 2014. Now, what did the SUNAT say here? It makes reference to the agreement of guarantees and measures for the promotion of investments in the Cerro Lindo project, and then it says the law applicable to the appellant to calculate the income tax is in relation to the Cerro Lindo Economic Administrative Unit, and it is, and then they cite a particular decree. For the record, this is page 11 of the PDF, and footnote 5 is relevant. And once again, this is CE 1128. Now let's look at another document. For the record, this is RE 415. This is a determination ruling in respect of Yanacocha from 2006, and we'll see it in just a second. Fine, this is page 1, and I think page 2 of the PDF for the record. And what does the SUNAT say here? I'm going to read it. The taxes, which includes payment on account of the income tax charged to the mining owner, must be assessed separately for each one of the economic administrative units for which a tax stability agreement has been signed. each of the economic administrative units for which a legal stability agreement has been signed. And then it doesn't say each of the investment projects for which a tax stability agreement has been signed. It says, once again, for each of the units. Now let's look at another document.
382.
This is a ruling of the intendancy in respect of Yanacocha from 2008, page 56 or 57 of the PDF. And here it says, Article 22 of the regulations indicates that the mining title holder independently calculates the results obtained for each of the concessions or economic administrative units. Now, once again, it doesn't say the results obtained for each investment project. It says for each of the concessions or economic administrative units. And now let us look at yet another document for the record.
32.
This is the ruling by the tax tribunal, Milpo 2022.
Going to have a question. For
Absolutely.
Them. Okay.
Páginas 9 y 10.
Pages 9 and 10 of the PDF, and it says the Cerro Lindo and El Porvenir EAUs are subject to the income tax regime in force on the aforementioned dates. So once again, it refers to the economic administrative units and does not say investment project. And let us look at yet another document.
1131.
Resolution of the tax tribunal in the Milpo case from 2022. So this is a recent document after the Cerro Verde resolutions in 2022. What is the tax tribunal saying? And just to clarify, this is with respect to stability agreements to which the same general law in mining in Cerro Verde applied. What does it say there? The tax tribunal recognizes the stabilized regime for each economic administrative units. The exact words are the Cerro Lindo and El Porvenir economic administrative units are subject to the income tax regime in force on the aforementioned dates. The Cerro Lindo and El Porvenir EAUs. So we have just seen at least six documents in the record, but there are many more, but we don't have so much time that expressly say that the stability agreement applies to economic administrative units without making any mention of investment project. Correct?
Las frases que usted...
The phrases that you have taken out say what you say, but you've taken them out of context. But yes, what you say is what is up on the screen. Now, a specific question in terms of context. When you read these resolutions, that anywhere did they say the general law in mining does not apply to economic administrative units? It applies specifically to investment projects? Yes or no? When I read these rulings, the first I can say is that they don't address the subject matter you're talking about, none of them. And we could review all of them. We could show you that none of them addresses the issue that you're talking about. Well, fortunately, the tribunal has them in the record, and I've just shown that they refer expressly to stability agreements, and they expressly state that they apply to economic administrative units.
Necesitaría 4 o 5.
I would need 4 or 5 minutes to explain why they're irrelevant and how the tribunal can easily reach that conclusion. You can do that on the redirect. But I suppose that you would agree that when the SUNAT carries out an assessment in respect of a company and looks at the stability agreement, it looks at the stability agreement and renders its assessment mindful of what it says. I think that you are confused about what exactly SUNAT does. Let me put it as follows. So your position is that when the SUNAT is going to assess a taxpayer, when they have a stability agreement, they ask to see it, right? They might not. So what you are affirming before the tribunal is that the SUNAT sometimes audits a taxpayer without even knowing whether they have a stability agreement. Is that your opinion? if you review what the SUNAT is discussing in these cases, such as bonuses for managers or characterizing investment in a building as an asset or not as an asset, the agreement is not relevant. Therefore, if what you want is to establish the scope of the agreement, obviously it's going to review it. But these are totally different issues that are raised in these cases. We have seen, and I see this as an attempt to contextualize, but does the SUNAT made express reference to the stability agreements, and it made a reference to income tax to know what tax would apply, to know what is the applicable regime. It needs to bear in mind the stability agreement, correct? Is that correct? Is that correct? In some of the cases that you cite, yes, it mentions the different rates. So we've just seen rulings that clearly speak of economic administrative units and not investment projects, correct? I should note that the subject matter of litigation is that the investment that lies outside, and here there's no litigation about an investment being outside of the economic administrative unit that is not covered by the agreement. SUNAT has not ruled on what you've just said in any of these cases, which is what is at issue here. Very well. The tribunal, once again, has the documents and will be able to see specifically what they say and what they don't say. You told us in your reports, and it's paragraph 115 to be specific. First or second report? Second. Very specific. I just want you to confirm your testimony there. You say that when a primary legal provision is drafted in a obscure, ambiguous, imprecise, or contradictory fashion, making it difficult to accurately interpret its scope, and that it could apply Article 170 of the tax code, correct? It's a very simple thing. I'm asking you to confirm what you said in paragraph 115 or not. Well, if you look carefully, there's a footnote on that paragraph, which is of the author that we've cited. But can you confirm what you've said in that paragraph? Yes, that is correct. And I also would suppose that you confirm what you told us this morning regarding Article 92 of the tax code, that taxpayers have a right to waiver of interest in cases of reasonable doubt. You said this at 12, that you recognize that under Peruvian law, taxpayers have the right to waiver of penalties and interest where, in those cases where there's reasonable doubt. Can you confirm what you told us this morning? Yes or no? If they have the right, yes, indeed, but there is a power that has to be exercised. I just wanted to confirm that you ratify that that right exists.
Okay, entonces
So you just mentioned the power of the state. Let us turn to that point. I'm going to take you, to try to be quick, to paragraph 153 and 154 of your second report. There you refer to the power of the state that you've just mentioned, and you say the power of the state should be exercised under the parameters of the law and the legal principles set forth in the political constitution. And at paragraph 154, you said that the power of the state and the exercise by the state of those powers should be respectful of the constitutional tax principles and the laws. Do you confirm this part of your testimony, yes or no? I'm sorry, what paragraph is it? It's up on the screen, paragraphs 153 and 154, and I could repeat for the record. There you say that a power of the state should be exercised under the parameters of the law and the legal principles set forth in the political constitution. That's paragraph 153. And at 154, you say the power of the state, the exercise by the government of this power, should be respectful of, or must be respectful of constitutional tax principles and the laws. Do you confirm this testimony, yes or no? That is right. And as it also indicates there, the power mustn't be understood as an arbitrary act of government without objective criteria. Thank you, Mr. Bravo and Picon.
Thanks. Do you have questions?
I do, if I could just have 1 minute to confer with my colleagues. Thank you. Just a few, hopefully very brief questions. The President and Arbitrator Tawil asked you about the application of Article 170 of the tax code and the waiver of interest and penalties. Do you remember that? And there was some discussion about a clarifying provision, one of the requirements of Article 170 in order for it to apply. I'd like to show you in your reports your first report at paragraph 73, what you said about the requirements for a clarifying act. If you could explain to us
I don't believe
what you're saying in this paragraph.
Is this in response to the cross?
It's in response to the tribunal's questions and several of your questions regarding clarification.
Well, it is not specifically with regards to my cross, but if the tribunal wishes for them to address it given the questions, then of course go on.
Thank you. Please. So it's on the screen. You can see this section of your report. Could you explain what you're saying here about the requirements for a clarifying provision for Article 170 to apply?
Sí, el artículo 170.
Yes, Article 170 establishes requirements for the state to be able to exercise that power. And those requirements presuppose first that there is a mistaken interpretation of the provision. Second, that the debt has not yet been paid. And three, that there is a clarifying provision, but not just any clarifying provision. It has to be a clarifying provision that says that Article 170, Section 1 applies, and it has to be a provision through one of the vehicles expressly indicated by Article 170, law, a legislative decree, supreme decree, or resolution of clarifying observation.
It's also in response to one of the president's questions. She asked you about the example of the company Tintaya, about keeping separate accounts. And I'd like to bring you to your reports again, your second expert report at paragraph 57 to paragraph 59. Here you cite and quote from a SUNAT resolution in the case of Tintaya, and if you could just explain to us why you quote to that resolution and what is relevant there.
Correcto.
Right. In the case of Tintaya, when you have an economic administrative unit, you could find more than one investment project with different tax regimes applied to them. In this case, it was established that since the benefits were different, and the accounts had to be had separately to make sure that you knew what tax regime was applicable to each one of the projects.
Further questions?
Thank you. From the tribunal side, there are no further questions, so you are released as experts in these proceedings with thanks. Thank you.
Muchas gracias.
Thank you.
Shall we then right away continue with the claimant's damages expert, or would the court reporters prefer that we have a short break because they will probably have a presentation again and this will extend the 90 minutes of our court reporter? So, yeah, then we make the 10-minute break now and continue at 2:45.
Thank you, Madam President.
Good afternoon. We come to the final part of our evidentiary hearing for today, the quantum. A welcome to our quantum experts nominated by claimant, Mr. Pablo T. Spiller, so Mr. Spiller, and Ms. Carla Chavich. Do I pronounce it correctly? Okay. You have seen us, I think, before on screen. Otherwise, I introduce ourselves. My name is Inka Hanefeld, presiding arbitrator, Professor Tawil, Dr. Cremades. Can you please be so kind to read out the declarations under Article 35.3 of the rules?
Good afternoon. My name is Pablo Tomas Spiller. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Good afternoon. I'm Carla Chavich. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. I expect you have your expert reports CER 1 and 6 in front of you. Is there anything you wish to correct?
No, nothing at all.
Perfect. Then we can proceed with your presentation.
Okay, very good. First of all, good afternoon, Madam President, members of the Tribunal. Pleasure to share a few minutes with you. In today's presentation, which you have in front of you, we'll start with a description of how we assess damages in this case, and then devote the rest to talk about our agreements and disagreements with Mrs. Guzman's, the expert of respondents. So if we go to slide 3, there you have our instructions, main instructions. Claimant, as you know, filed claims on its own behalf and on behalf of SMCB, and we were instructed to compute damages at the level of SMCB. Now, there are two claims in this arbitration presented by claimants, the main claim and the alternative claims. All these claims come or arise from a series of assessments on royalties and new taxes, penalties, and statutory interest that Peru imposed on SMCB. The main claim consists on all those royalties and new taxes, penalties, and statutory interest, while the alternative claim focuses on the penalties and statutory interest, as well as incorrect calculations of tax assessment, as well as unreimbursed GEM overpayments related to the concentrator. There are in total $1.2 billion in assessments, and when I talk about assessments, always includes royalties and new taxes, as well as there are penalties and statutory interest, a bit more than half on the latter, and royalties and new taxes around $600 million. Now, as it relates to the alternative claim, there are unreimbursed GEM expenses for $64 million and $19 million in what some inappropriate or incorrect tax calculations. Now, as you might have heard, SMCB already paid 97% of the assessments, and remaining only $33 million in PTU obligations. Now, let's move to the next slide. In this arbitration, given the equivalence in financial economics of two ways of measuring a value of a firm, whether via the lost cash flows to the firm or via the accounting identity that says that the value of a firm equals the sum of its debt and its equity, we implement damages by looking at both sides of the equation. We assess damages on the left side, on the right side, and we'll tell you in more detail in the next slide. In the prior arbitration, where the Sumitomo arbitration, SMMCV arbitration, the claimant was a shareholder, and here the difference is that the claimant is claiming for himself and also for SMCV. But in the prior arbitration, we only assess damages based on equity. Now, why do we do this here as well? Because the assessments had no impact on the value of SMCV debt. SMCV continued making its payments in a normal fashion, never entered into arrears or default. And as a consequence, the measures had very little impact had no impact on the value of the debt. And as a consequence, all the impact of the measures translated into a reduction in essentially the equity component. And therefore, we can assess damages to SMCV by looking at how the reduction in the equity component of SMCV came. In other words, by reduction in cash flows to equity. Now, in this arbitration, we also look in the next slide at the reduction in cash flows to SMCV. And as the identity will suggest, the two results should be very similar. In theory, identical. They are in practice similar, and very little difference between the two, as we'll show soon. So let's, in the next slide, let's go to how we go from assessments to damages. As mentioned, there are $1.2 billion in assessments, but not all $1.2 billion translate into damages. Why is that? Well, because the payment of such assessments, it has tax savings. When you pay royalties, you deduct that from your income tax. And as a consequence, that there is a substantial reduction, given that the income tax is 30%, there is a substantial reduction in that component. At the same time, Peru reimbursed some of the GEM payments associated with the concentrator, not all, so that's GEM mitigation. And some of the income tax assessments that SMCV had the consequence that starting with those assessments or later on, the SMCV was forced to depreciate some of its assets on 20 years rather than 5 years, and that implies that there is some depreciation mitigation down the road. In sum, from $1.2 billion in assessments, the nominal cash that they would have saved but for the measures is $813. In other words, there are $400 million that do not translate into damages. Now, when looking at the loss in the equity component of SMCV, we focus on when this money saved in the but for scenario when these payments would not be done. We assume that SMCV would have distributed those in terms of dividends or available for dividend distribution in the next time that SMCV actually distributed dividends, which started in 2018. And that in the interim, we assume that SMCV would put that money into short-term instruments, obtaining a return of short-term deposit rate. And so that brings you 813 to 819 as of the date at which those cash available would have been distributed or available for distribution. Now, this 819 are at a very different points in time, and since we have been instructed to value damages as of date of the award, which is proxy in our reports by the date of our report, we bring forward these undistributed dividends to the date of the putative date of award at the cost of capital of dividends, which is the cost of equity of SMCV. That gives us damages for 942 million. Now, if we look at the cash flow, lost cash flows to the firm approach, we start with the same. In the next slide 8, we start with the same 1.2 billion. We get the same tax savings, depreciation, debt mitigation to move from 1.2 billion assessment to additional cash available as at 813. Now, these additional cash available are as of the date that the payments took place. To bring those 813 to date of valuation, we bring it at the relevant cost of capital of cash flows to the firm, which is the weighted average cost of capital, and we obtain therefore damages of 1,043 million, slightly different from what we obtain under the free cash flow to equity approach. Now, in slide 9, we compare these two measures and these two damage assessments, and also provide some sensitivities to the lost cash flows to the firm approach by bringing forward the payments at two different update rates. The reimbursement rate, these are SUNAT reimbursement rates that would have been applicable to the payments affected by SMCV, and as you can see, the average reimbursement rate, which is normally for involuntary payments, is very close to the WACC, to the WACC of 7%, and that will, as a consequence, lead to damages very similar to what we estimated for this approach. If we bring those payments to date of valuation using Peru's cost of debt, which for the period was 3.1%, then damages are 4.6 less than our base case of 942.4. Overall, as I mentioned, the damages assessed by one or the other way ought to be very similar. They are. Our base case is the lost cash flows to equity approach. Now, this is done for the main claim. We also do the same exercise for the alternative claim. I won't repeat everything, but you get that in slide 10, which is where our application of the lost cash flows to equity approach, where we look at damages from the perspective of looking just at the equity component of SMCV. The damages are 719 million, or 720 million. Looking at the lost cash flows to the firm approach, which is slide 18, we get 785 million, again, 10% above or so. And in slide 12, we provide the same comparison that we did for the main claim, and the results are qualitatively the same. The damages are around the assessment under the cash flow to equity approach of 720. Okay, that deals with our how we compute damages, our two approaches. Now, let's move to the agreements and disagreements. In this slide 13, we show you that essentially there are not a lot of disagreements between the claimants and respondents experts, between both sides. We both agree on what the assessments are and the dates. We agree on the payments, the magnitude, and the dates. We agree on the netting of tax savings, both income tax and PTU savings. We agree on the applicability of the depreciation and the debt mitigation. We agree on the damage methodology, lost cash flow to equity or to SMCV. And we also agree on the term deposit rate that will be used until dividend declaration. So there isn't much that we disagree. And in fact, in the next slide, we show you that the only significant differences are two. Economic differences. But let's start with very minor differences. There are three very minor differences, those that appear in the bottom, relating to Mrs. Guzman claiming that the outstanding liabilities are not damages, that the tax corrections that we implement are not applicable, and that the depreciation mitigation ought to be discounted at a different rate. Overall, even the three together have around 3%. It's not really a significant difference, and I'm not going to spend more time on that. There are two economic differences, and that relate to essentially either the updating rate or the date of dividend distribution. Mrs. Kunzman's claims that in the cash flows to equity approach, the reasonable assumption is that SMCB would have distributed the but for dividends, or will have these but for dividends for distribution as of the date of the award, meaning sometime in the future, which will explain to you why this is economically wrong. In the case, Mrs. Goodman says that you, the tribunal, accept our approach to dividend distribution as reasonable, then she disagrees on the application of the cost of equity from the date of distribution, dividend distribution, to the date of the award, and instead advocates for a one-year Treasury bill plus 2%. Now, that has around 10 to 12% reduction in the damages. We say significant, but it's not extreme. The way that Mrs. Guzman reduces damages significantly is in two ways, which are not economic, but rather legal. One is that she introduces what she calls a treaty claim, which means that taxes cannot be claimed in this arbitration, and therefore that would lead to a reduction in damages of around 40%. And also that SMCB should have mitigated penalties and interest by paying all the assessments much sooner, which has the significant implication that damages are reduced by 60 to 70%, which means that Peru will retain 60 to 70% of the damages. Now, my colleague, Ms. Chavich, will continue with the presentation.
Thanks, Professor Spiller, Madam President, members of the Tribunal. I will cover the areas of disagreement, starting first with these two adjustments that have the larger impact and are related to legal issues, but just to see the implication on the economics. The third argument relates to the mitigation scenario. Ms. Guzman assumes that Cerro Verde could have saved most of the penalties and interest, and that's that Peru should not reimburse that amount to Cerro Verde. In particular, she assumed that over 90% of the penalties and interest already paid should not be refunded to Cerro Verde. As we see here, that implies that Peru will retain $572 million and will only refund claimants with $44 million of the penalties and interest paid. While this is an economic issue, it has also an economic argument behind, and it has its flaws. The idea of mitigation in this context is for claimants to take actions that will reduce harm that, if compensated by respondent, it will result in a harm in respondent paying a compensation higher than the damage inflicted. But that is not the case here. Peru is not going to be harmed. Peru is already in possession of this money. Peru is already in possession of this 572 million here. Thus, Guzman adjustment in this mitigation of penalties and statutory interest will just result in a windfall in Peru retaining that money paid by Cerro Verde. The second difference refers to Ms. Guzman's treaty claim. In this claim, and in this treaty claim, per legal instruction, Ms. Guzman removes all the new taxes and the related penalties and statutory interest. As Ms. Guzman notes, this adjustment will not apply to the main claim if the tribunal finds a breach in the stability agreement. We don't opine on this issue. We compute damages based on the main and the alternative claim as defined by claimant and as explained by Professor Spiller before. Now, getting into the economic differences, I will start with the issue of the update. And the update has two sides of it. One is when the dividends will have been distributed and until when we start updating those dividends. And the other discussion is, alternatively, is the update rate to use. So the first position of Ms. Guzman is that Cerro Verde would have not distributed as dividend the additional cash it would have had but for the disputed payment. Her assumption is that Cerro Verde will just keep all this additional cash with no use in a short-term deposit until a future day, until the date of award, getting around 1% per year of interest. But that is not reasonable for a business to do. And let's look into this in slide 18. First, it's important to note that the shareholders of Cerro Verde, but any investor, invest to expect to receive a return. Otherwise, they wouldn't invest in a company. They are not going to accept for a company just to hold cash, excess cash with no use for a number of years without getting a reasonable return for it. And this is consistent with Cerro Verde's history. As we see here, the blue bar shows when dividends were paid by the company. We see that Cerro Verde actually paid dividends, with the exceptions of periods in which it was saving and for undertaking a big investment, for example, the expansion between 2011 and 2016, that would generate a return in the future, given that expansion to the shareholders. Cerro Verde didn't distribute dividends also in 2020 due to COVID uncertainty, and then resumed dividend distribution in 2021. So we know that between 2018 and 2022, despite the disputed payments, Cerro Verde was distributed dividends. That means that Cerro Verde set aside the cash that it needs to operate and distribute the excess cash as dividends, despite making these payments. There is no reason to assume that in the but for that disputed payment, that additional cash would not have been distributed to the shareholders. For that reason, in our free cash flow to equity approach, we assume that Cerro Verde would have distributed the additional cash in the dates when it actually distributed dividends. This way, we don't do any second guessing on when that dividend would have happened. We just follow the actual dividend, but the additional cash would have been distributed on that date. Alternatively, Ms. Guzman says that even if you assume that dividends would have been distributed in the dates in which dividends were actually distributed, as we did for the reasons discussed before, those dividends should be updated to the date of award, to the date of valuation, at a 1-year U.S. Treasury bill plus 2%. This rate, however, fails to compensate claimants. In slide 20, we show the difference rate discussed in this case. As we mentioned, the impact of the assessment is to delay dividends to shareholders. Cerro Verde was not able to pay this additional cash as dividends in the dividend distribution date, and it will be, if it comes in the word. We update. I can repeat, sorry, apart that. Cerro Verde was not able to distribute the additional cash as dividends at the time of the dividend distribution. And thus, we update those dividends to the date of award at the cost of equity. This is the minimum return that the claimants would have, or the shareholders would have accepted for that delay in the dividends. The shareholders of Cerro Verde would have only accept a delay in their dividends for a return that is at least the cost of equity. It's the minimum return a shareholder requires to invest in a mining project such as Cerro Verde. In the free cash flow to the firm approach, we consider the WACC, that is the weighted average cost of capital, so we consider both sources of financing, the equity and the debt. As we see here, those rates are in line with SUNAT's statutory rate. That is the rate that SUNAT has to pay or to refund companies that made overpayments due to SUNAT improper assessment. On the contrary, Ms. Guzman rate, that is the U.S. Treasury bill plus 2%, that was around 3.4% during the 2018-2022 period, fails to compensate claimant, and it does not reflect the financial cost faced by the company. And now let me touch briefly on two minor differences that have less of 3% of impact in damages. The first one is the outstanding liabilities. Ms. Guzman excludes them from damages. The outstanding liabilities are PTU, that is the employee profit sharing, and it refers to 33 million, that implies around 3% of all the assessment. These obligations are recorded in Cerro Verde's book and still pay interest until paid. We understand further that they are enforceable and that Cerro Verde would have to pay them regardless of the outcome of this arbitration, and thus we continue to include them as damages to the company. The second minor difference affects only the alternative claim. In this claim, Ms. Guzman, based on the opinion of Peru's tax experts, excludes the tax corrections. It doesn't include them in this claim. That results in the leaching facilities being affected by the new taxes. So we understand that there is no disagreement that the leaching facilities were stabilized and should not be affected by the new taxes. However, some of SUNAT assessment were applied to the whole activity of Cerro Verde, affecting also the leaching facilities. For example, the complementary mining pension fund was assessed over Cerro Verde's taxable income entirely, including the income of the leaching facility. To correct for that, in this scenario, we apply the same criteria that SUNAT applied to separate between stabilized and allegedly non-stabilized activities for royalties and special mining tax, based on the percentage of sales. So, to conclude, claimants present two claims, the main and the alternative claim. We assess damages based on the lost cash flow to equity, which is in line with the damages that arise from applying the lost cash flow to the firm and its sensitivities. We assess damages as of the date of award. In our second report, we present damages as of September 22, that as a proxy of the date of the award. We have agreement with respondent experts on the value of the assessment at 1.2 billion, on the disputed payments that are over 97% of this assessment, and how we go from those assessment to damages. We have minor differences that are less than 3% as the last issues that we discussed. We have a difference that have around 10% impact that relates to the updating, the rate or the timing. But the main difference that we have in the scenarios is the penalties and interest mitigation that has an impact of 60 and 70%, in which Ms. Guzman assumes that Peru should retain money that was already paid by Cerro Verde. And with that, we conclude our presentation.
Thank you very much for your presentation. This was very helpful, and it summarized very well the main areas on which also our questions and I would focus. So just in order to get it in a precise, a very big economic difference now lies in the penalties and interest in our claim under the alternative scenario, right? So in the main claim, there is at least no jurisdictional debate. And in the alternative claim, if I understand it correctly, Mrs. Kunzmann states that taxes are not allowed for damages claims under the treaty, but this exclusion does not apply under Article 22, 3.6 to the breach. So I understand main claim has no jurisdictional issue, alternative claim has, according to Mrs. Kunzmann, but you did not opine on that, right? Is this correct?
We don't opine on legal issues, no.
Okay. And then there is another a major question that I would have, and this concerns the double recovery aspect with regard to the other arbitration. I wonder, is it your position that we should award claimant 100% of those damages that you identified, if any, or is it just the 53.56% shareholding?
Okay. As it relates to the double recovery, my experience in arbitrations where there are multiple claims is that the tribunals issue decisions that condition the payment so that double recovery will not take place. So it's completely up to you how to do it, and I believe that's the appropriate way, as each arbitration is on its own, but you can condition. Now, as it relates to the claims and how to compute that, here they are making, claimant is claiming on its behalf, but also on behalf of Cerro Verde. On behalf of Cerro Verde, obviously you could say that there could be, if you make an award on behalf of Cerro Verde, it could be double recovery if the other arbitration also grant one shareholder a particular award for that. But you can stipulate in your decision how to prevent that, so that if the other, you can condition your award, or you can stipulate some monies will be held on escrow and depending on the other award, etc., etc. You can do that. But my understanding is that here claimant is claiming on SMCV, on the behalf of SMCV, so you have to determine whether that's an appropriate claim, independent of the double recovery, and then you can make a stipulation concerning double recovery. As it relates to claimant itself, obviously he has a share of the equity, and this is, I imagine, on complete your discretion. I don't know exactly what the legal ramifications are. We were not instructed to compute damages to 54%. We're assessed, as we said in slide 3, to compute damages at the level of SMCV. Would you compute damages at the level of Freeport, then it will be more or less 54%. But that's a different. I'm not sure how that relates to the claim here. Is beyond my expertise. Now, if you ask us, you tell us, okay, experts compute damages for this or that, we can always do that.
Then we stop for the moment with our questions to give the parties enough time to do their questioning.
Thank you, Madam President. Good afternoon, Dr. Spiller, Ms. Chavez. You're experienced as experts and experienced in this sequence in particular, so I will just very quickly spin through a couple of logistical parameters. One is, you already know, the importance of focusing on a short answer. We're on an ever shrinking clock in this case, and because you are appearing together in this proceeding, as you know, we've agreed that the rules are that one of you will decide who answers the question. Only one of you will answer the question unless you specifically ask the tribunal for permission to chime in or to add on to the first answer. And for convenience, I'm going to direct most of my questions to Dr. Spiller. And of course, Dr. Spiller, you can say if you'd prefer for Ms. Chavich to answer the questions instead. Also, I assume that you've had the chance to review the transcript from our exchange in February when we last met in the other related arbitration, correct?
Yeah, I reviewed that.
Okay.
Yes.
So I will caution that part of this may feel like something you've seen before, because we'll be covering some of the same territory. But of course, the most important people in this room are the ones who weren't with us in February, and so we will be covering.
So I won't answer déjà vu, no?
Exactly. Assume déjà vu, and we'll go from there.
We go from here.
Right. Yes. So, okay. Just one question on that sort of allocation of responsibilities. Dr. Spiller, could you explain why you asked Ms. Chavich to co-author the report with you? Are there particular areas in the report or subjects on which you didn't feel comfortable opining and wanted her expertise? Or what was the reason for the joint report?
We work together very well, and we normally write reports together. It's our normal practice within our practice to co-author with colleagues, so it is no different here.
Is there a division of responsibilities in the subject matter or in who gets into which level of detail, for example?
Not really, no. We work as a team. We are responsible for everything.
So, just so I can anticipate then, how do you plan to decide whether you'll answer a question or whether you'll pass it over?
That we'll see how it goes, and depends on divide more or less the time, and we'll decide.
Okay. All right, just a couple of questions on background and then also on the parameters, because I do think on one of the questions that even the president posed there, it suggests that there may be some confusion. But first, on your respective backgrounds, in the interest of time, when we met in February, Dr. Spiller, we discussed your background in investment treaty arbitrations, which is extensive. I think your annex suggests, I counted somewhere in the neighborhood of 50 cases in which you've appeared as an expert in investment treaty arbitrations. Is that correct?
I don't know how many cases.
Okay.
Maybe more, I don't know.
We established in February that 3 of those cases are cases in which you've been retained to appear as an expert testifying for the respondent, the state. Is that correct?
That was correct. I failed to mention that I also had an engagement with Poland on the Serbia versus Poland pharmaceutical case. I forgot about that. I'm sorry about that.
Okay, so 4 then.
Yeah, although one I believe were 2 cases, but yes, more or less like that.
Okay. And in February, I read out, and I will not take the time here, the names of some 32 cases that I had been able to identify in the public record where you had appeared as an expert engaged by claimant. And then since then, with better research, I've identified 7 more. So that would bring our total up to 39 that I found, and 4 that we've discussed for respondents. So 39 for claimants and 4 for respondents. Is that right?
Well, I don't know, but...
Okay, well, that's fair. I should tell you...
When you mentioned the cases last time, they were all appropriate, so I imagine the additional 7 will also be. I don't have a problem with that.
But to be fair, I shouldn't force you to assume something that's not in front of you. So just quickly, those cases are Hydro Energy versus Spain, BSG versus Guinea, Windstream Energy versus Canada, Global Telecom versus Canada, Crompton versus Canada, Odyssey Marine Exploration versus Mexico, and Sanam Investments versus Laos. Do those all sound like cases in which you are engaged as an expert?
I don't think Qualcomm versus Canada. I don't recall that case.
Not WorldCom's Global Telecom versus Canada?
A Global Telecom, yeah, it could be.
Okay.
Yeah.
Okay. And then, Ms. Chavich, again, sort of based on what I could find in the public record, I think in February we identified 6 cases in which you had appeared as a testifying expert in investment treaty arbitration, all of which were for claimant. That was Alicia Grace versus Mexico, Lopez Goin versus Nicaragua, Gabriel Resources versus Romania, Glencore versus Bolivia, Total versus Argentina, and Eco Oro versus Colombia. Are those correct?
No, there are. I was not a testifying expert in Eco Oro or Total and Gabriel either, I think. So those are in.
I see. So those were not cases in which you were a testifying expert. Okay. And I was not able to identify any respondent side testifying engagements. Is that correct?
In treaty is correct.
Okay. Thank you. All right. So then moving to instructions and sort of how you proceeded with the calculations that you did. So we've got the main claim and then the alternative claim. The main claim is assuming that each and every royalty assessment, each and every tax assessment, and the penalties and interests associated with those assessments are a breach of the stabilization agreement and a breach of the investment treaty, correct?
I believe so, that these are, we were instructed that all those assessments were breaches, and I believe that the claimant explains that they are breaches of the stabilization agreement and or the treaty.
Right. And if we were to focus exclusively on treaty claims, and here I'm going to speak exclusively of claims under Article 10.5 of the treaty, your calculations still include all tax assessments and penalties and interest in the main claim, correct? Even if we are speaking only of treaty breach.
Yes, but with the caveat that we were not asked to perform that assessment. We were not given a list exactly of what is a treaty, what is a statutory, a stability agreement in detail. So it's not part of our instructions. Okay, so our instructions is to these are the breaches of the treaty and or of the stability agreement and or the treaty, and these are compute damages based on that. So we were not instructed to look in detail of that jurisdictional issue, whether SMT or stability agreement.
Okay. So again, focusing still on the main claim, if the tribunal were to decide that taxes, and let's be comprehensive, so taxes and the penalties and interest on the taxes were outside of their jurisdiction for purposes of a treaty claim, they could not look to your report to find the correct number for what should be claimed in the main claim, correct?
Our report will not provide that. Our model could provide, because our model has each and every assessment in it. So if the tribunal makes a determination concerning that, and we get a list, an appropriate list of which each assessment correspond to which breach, then we can exclude certain whatever assessments correspond and whatever penalty and interest, if so, the tribunal determines. So our model, which Mrs. Guzman's model is also based, is extremely detailed, goes to incredible detail. So the tribunal can order more or less whatever you want, we can do with the existing model.
Okay. But on the face of your report, that number is not available to them?
No.
Okay. And on the alternative claim, which is only for the penalties and interest, both on taxes and on royalties, again, you continue to include tax penalties and interest in that claim, regardless of the jurisdictional question that's been in front of the tribunal, correct?
Correct.
Okay. So that jurisdictional question affects both the main claim and the alternative claim calculations, correct?
It may affect, depends really on how the tribunal interprets that jurisdictional issue. My understanding on the penalties and statutory interest, and that is something that claimant explained, relates more to the penalties and statutory interest should not have been implemented or imposed, and for reasons of uncertainty. But that's a different thing, and it's an area that I don't want to go beyond that because that's the extent of my understanding. So,
right, we can leave that jurisdictional question to the lawyers for now. All right, and then the other thing that I just want to establish is that, again, if the tribunal were to find liability for maybe, say, let's put ourselves in the alternative claim. If the tribunal were to find liability for some, but not all, of the penalties and interest, for example, if it upheld penalties and interest where SMCV had an untimely waiver request, your report won't help them segregate different categories of the penalties and interest. You say your model would do that if asked, but that your report will not. Is that correct?
That's correct.
Okay. And did you do any calculation to try to attach a damages figure or liability specifically to claimants' claims about procedural issues in the tax tribunal?
No.
Okay. And if the tribunal were to find that SMV could and should have mitigated to avoid some of the penalties and interest, but on a different date than, for example, Ms. Kozenspan used, they would not be able to use your model to adjust for that, correct?
Oh, yes, they could.
They could use your model. Could they use your report?
Well, the same way they cannot use Mrs. Guzman's report. If they found different dates, they had to be tinkered. So the model can be used for almost anything that the tribunal wants to do concerning taxes, penalties, royalties, etc.
Okay. And then just a question about the overall approach. I've seen in multiple places in your report references to taking the approach that, sorry, hold on. Switching to the other page of my notes. So the framework that you're applying is to answer the question, what we call the but-for question. That is, to put SMCV in the position that it would have been in, but for the alleged breaches of the treaty or the stabilization agreement, correct?
Yes, correct.
Okay. And that is, just for reference, I don't think we need to go look at it, but we would find that in your first expert report at paragraph 96. We would find that then echoed in claimant's briefs. Well, let's just very quickly, just to confirm, let's go ahead to tab 1. Your first expert report is at tab 1 if you need to look at it. We'll also throw it up on the screen. And paragraph 96, which is page 56 of the PDF, where you explain that your objective is to restore SMCV to the position it would have been in but for Peru's breaches, correct?
That's correct.
Okay. And that's the sort of fundamental question that we should ask ourselves with each of these steps, with each of these categories of damages, right?
For each of what?
For each of the elements of the damages that you've calculated, correct?
The elements being exactly what?
Well, it is the overall question that you're asked to answer in your calculations. What would the situation, you have to assess what would the situation have been but for the damages, compare that to the actual situation, and then calculate the damages from the difference, correct?
Yeah, but for the payments, that's what you're saying, right?
Right. Okay. All right, so let's move. I'd like to spend just a few minutes talking about this question about dividend distribution.
Okay.
And here, as you've explained in your direct examination, there's the question of when we should assume the dividends would have been distributed, and then, if necessary, at what interest rate should be applied to bring those dividend distributions forward in time, correct?
Okay.
Okay. Now, and this is, as you identified in your direct presentation, this is an issue with a substantial impact. There's about $114 million at stake in the main claim and $83 million at stake in the alternative claim. Now, you're not here as a lawyer, but I assume you're familiar with the rule that it's claimant's burden to prove its damages?
Sorry, I couldn't hear the last words.
Sorry, I assume that you are familiar with the rule that it is claimant's burden to prove its damages.
Yeah.
So it's claimant's burden, we submit, to put on the table the information that would prove what would have happened. And in the case of this particular question, what dividends would have been distributed and when they would have been distributed in the but-for world.
Okay.
Okay.
I will let Mrs. Chavich to handle this line of questioning.
Okay. All right. And you have assumed for the purposes of this modeling that SMCV would have distributed 100% of the cash flows that it would have received had it not had to pay the assessments and penalties and interest, that it would have distributed 100% of those funds as dividends, correct?
Like the additional payment net of all the mitigation explained, that additional cash, that excess cash that the company would have had, yes, would have been distributed as dividends the same days when the company actually paid dividends despite these disputed payments, correct?
Right. So you're assuming that if SMCV had this additional money in hand, it would not have retained any of it for additional capital projects, for additional reserves. If it had had that extra money, it would have gone directly to the shareholders on the next available dividend distribution date.
Correct, because this is extra money, extra to the money that they already saved when they decided to pay dividends.
May I ask one question in this regard? Is this a categoric yes, or is it it depends? Because I could assume if they operated under a reinvestment of profit stabilized regime, they would have a greater incentive maybe to keep it rather than distribute it. So can you qualify your...
Yes, and that's why we follow the dates in which they actually distributed dividends despite making the payments. So that means that at that point, they already set aside the cash that they will need, for example, to pay debt, or if they have a CapEx plan, they already set that cash, and additional to that, they distributed dividends. So this is just extra new cash in a sense, and that is why we follow the actual dividend dates to avoid having the problem of saying, look, maybe they have the cash available before, but they could have make another use. No, let's focus just on the actual dividend dates that we know that at that point the cash needs were covered and they pay dividends, so they would have used this additional cash as additional dividends.
Madam President, if I may elaborate, if you wish, there is no evidence of a significant capital project in the books. That is, at the time that these dividends were actually paid in 2018 to 22, there is no evidence that the company had or was planning to do an additional concentrator or anything like that. There is just not evidence about that. So the money would have stayed in the company with no particular real use.
Thank you. Sorry for the interruption.
Well, if I may follow up on Dr. Spiller's add-on, because that's interesting. You didn't mention any such analysis of the company's operating plans or any investigations that you performed to determine whether the company had been considering additional capital activities in the 2018 and onwards period. And I don't see any mention of that in your expert report. Could you tell us, please, how you investigated the company's operating plans before you prepared your report?
We have an understanding by the financial of what is the payments that are coming, for example, for that. If there is a plan of the expansion, as for example, when you have the expansion that we show here between 2011 and 2016, it was explained in the financial statement that the company was undertaking first the feasibility study and then the plan. So that is explained in the financial statements of the company. But the main point here is that dividends were distributed in any case, so the cash hold was sufficient to cover the operational and capital needs that they have, with the exception of 2020 that the company, if I am not mistaken, we cite to the release, dividends were not paid due to uncertainty during that year, not because there was an investment plan, but given the uncertainty of that year, dividends were not paid. But in the others, all the other years, dividends were paid despite the payments.
I'd like to look at how you actually explained your reasoning in your report. So let's look at your second expert report at paragraph 37. So that's tab 2 in the binder and page 28 of the PDF. And here you've explained and you've given 2 reasons why you are assuming that the dividend distribution will happen, would have happened on the dividend distribution dates, and that it would have been a complete pass-through. I don't see any discussion here of your extensive analysis of the company's operating plans. I see here 2 reasons given. One, that you talk about the history of their dividend distribution practice, and then you also talk about their dividend distribution policies. Is that correct? Because I'd like to ask first about the dividend distribution practice that you're citing.
Yes, so the first reason that you see here is the practice and the fact that when we assume that dividends would have been distributed is when dividends were distributed. So in 2018 to 2022, exception 2020, and those dividends were distributed even after the disputed payment. So even after not having this cash, the company was able to set aside the cash need that they have and pay dividends.
Right.
And what we explain is that there is no reason to, and what we follow is, in reality, is like there is no reason to assume that more cash will increase your limitations to distribute dividends. And then we go to the policies.
Right. But you say here in the language that we're looking at that there is a well-established practice of distributing available cash as dividends, except in the years when the company was accumulating cash for capital investments. And you mentioned that also in your slide presentation, which I think is slide 18, which is a copy of figure 1 from your, let's see, first or second expert report, one of the two. Some from your second expert report. So if we could take a look at that figure. So I'm curious about the word except, because if I count correctly here, we have 18 years on this chart, and in 9 of them, half of them, no dividends are distributed. So that doesn't sound like an exception. That sounds like just as much of a rule as the dividend distribution practice.
The company, when they have excess cash that it doesn't have an use to, it distributed it. So that is what you see between 2007 and 2010. Between 2011 and 2016, there was an expansion taking place. The concentrator was expanded, a new concentrator was expanded. those years what you're doing is you are saving money and not distributing dividends to your shareholders because they are expecting to have a higher return due to this investment in the future. So it's a saving that you are doing now to then further have additional dividends in the future. You know that the revenues of the company and the profit increase after an expansion that triplicates their capacity. So the logic is that when you have money available and when you are a single project company, when you have money available and you don't have a plan on expansion, that money, if it doesn't have a use, should be distributed to your shareholders because you have to give a return to your shareholders. So the practice of this company is when we have a project that, like an expansion, that money could be reinvested because we are going to get a return that is at least the cost of equity. Otherwise, we are distributing dividends, and that is what we show here. And we see here also that I think that is the most relevant period, the period in which payments were made, and in any case, the company had available cash to distribute dividends.
Right. In fact, the company had more cash than it distributed, correct? So it did not distribute all of its available cash.
Correct. It distributed what is excess cash, correct.
Right. But if we look at, for example, Ms. Kunzman's second report at Table 9, which is page 23 of the PDF, that's also at tab 5 of the binder in front of you. And we look at those same years, she's put on this chart in Table 9, and then in Table 9 she's shown the cash balance, so she's shown that in fact they have more cash than they distributed. So they're obviously not distributing everything they've got available. Likewise, if we look at Table 11, we see the difference between retained earnings and dividends, and they've got retained earnings in excess of their dividends as well. So they're not distributing everything that they have available to them.
There are two different things here, and I will have to respond to them separately. Retained earnings is an accounting concept. So retained earnings are the amount of earnings that a company has generated during the past, doesn't consider the investment at all. So, for example, here you see that it says that the company has like 4 billion of retained earnings. That is the blue line. When you see the cash available in 2014, if you go to the previous chart that you were showing me, the available cash was almost zero or very low.
Could you go up to?
If you see 2014, you almost not have cash because you were investing all the cash in the expansion. So retained earnings really is not something that can be used to measure availability of any fund. It's just an accounting concept that accumulates accounting earnings without taking into consideration investments and other cash outflows. But just to be clear, I think that we shouldn't consider it. Now, regarding cash, as you see here, you accumulated cash for the first expansion, then you don't have, for the expansion of 2011, 2016, you don't have cash those years because you are using it for the expansion, and then yes, you accumulate additional cash. And not all the cash is distributed. You have to set aside cash for issues like, I have a payment coming for operative reasons, prices are volatile, so I need to have a cushion. So the management decides that there is cash that they need to hold. The cash that they distributed is the excess cash. They already had that excess cash despite the payment. That is the yellow bar there. What we are saying is that when you have the net additional payment, that additional cash will go on top of that excess. It's more excess cash available and should have been distributed at that point.
And so you just mentioned the management decision making. Management decides how much cash they need to save. Management decides how much cash that they can send out the door. Management, I assume, decides whether they should pursue the capital expansion programs that we saw in the 2012 to 2017 period, right? Those are free choices by the management at every point in time, right?
They are free choices within reasonable business, right? You cannot do an expansion plan that is not going to. It's not expected to generate a return because otherwise the board and the shareholders are not going to approve. Sorry. Otherwise the shareholders would not accept that. Sorry.
Okay. And you did not cite or find, I assume, because I assume if you'd found it you would have said so, any policy that either directs the company to to distribute all available cash, or any rule of thumb or policy that creates a default that they'll distribute a certain percentage of cash available. The only policies that you cited were policies that simply permitted management to make dividend distributions. Is that right?
We cite to, and we can see exactly the term of the policy. What they explain that dividend should be paid that dividend is going to pay once liabilities, and yes, if you can show it, probably is better than me trying to.
Yeah. So this is Exhibit CE 934. This is the dividend distribution policy of SMCV, and specifically, if we can highlight the paragraph, the sentence that says, according to this policy, about halfway through. But of course, it's just a paragraph. You can read the whole paragraph.
Yes,
No
correct.
objections.
Yes. And I think that this is in line, right? The company is going to use their profit as much as if they have any continued growth opportunities, face any financial obligation, and then dividend distribution will take place. We know that all those befores had been covered because the dividends were distributed. So we are in the point in which we are already distributing dividends in 2018, 19, 21, and 22.
And in the periods where the management was making the major capital investments in the concentrator expansion from 2012 to 2018, we know that there were large financial obligations that were not paid nevertheless, right? That was when all the tax assessments were pending.
That they were financial obligation. There was an outstanding debt that was also used to finance the project, and it was paid as payments come. It was not a default in a sense. I don't know what.
I'm actually referring to the tax obligations, which this policy would suggest that one should first pay your tax obligations and then pay out your dividends. But we don't. That didn't happen, did it? They didn't follow that policy.
Well, they follow the policy of paying what they consider were obligation that otherwise you will be in default. Same with financial obligation. This doesn't mean that you have to cancel all your debt before paying dividends. You have to be in good terms with your debt before paying dividends.
Let's switch gears and talk about the mitigation, which is one of the disagreements that you've identified between the experts. SMCV did pay some of its taxes when assessed, and that stopped the running of penalties and interest. And when that happened, you took account of that in the damages calculations, correct?
Yes.
Okay. So we know that they knew how to do that.
Sorry, can you repeat that?
Never mind. Sorry, I'm just trying to accelerate through a few points here. All right, but obviously, because we have large accumulated penalties and interest, we know that they did not pay all of their assessments when assessed. They chose to let some of those obligations hang while they contested them in the administrative and court proceedings, and that's how they accrued penalties and interest, right?
I believe that they follow the tax proceedings, yeah, these amounts were not enforceable yet. In Peru, my understanding is that once there is a decision of the tax tribunal, it becomes enforceable and payable. But yeah, I think that they took whatever management strategy or decision they took is what they did.
Right. And I mean, that decision to choose between paying your taxes under protest and stopping the penalties and interest, or not paying the assessments, contesting them, and waiting to see what happens at the end, that's what causes more than half of the damage, more than half of the assessments claimed here, right? You broke this down in your first slide.
I think that it is claimant's claim that the reason why that amount is because of the inappropriate tax and royalty assessments. I think that's the reason, and whatever they were doing was they were following the administrative process in contesting the tax obligations, with expectations of recovery from SUNAT at the reimbursement rate, which is reasonably high, very close to the cost of capital of the company. So,
But it's your understanding that they had the option to pay the assessments when received,
and also
they would not have accrued the penalty and interest, correct?
Yeah, and also to ask SUNAT to reverse or review its policy and pay back with interest at the reimbursement rate. So it is.
And that's common.
That's the options. Whether it's one or the other, it seems that both are legal to me.
Right. So, and this is common in taxation in many, if not most, countries in the world, that you have the option to pay under protest, avoid the penalties and interest, contest the issue, and if it turns out you're right in the end, you get your payment back with interest. This is the statutory rate that you're referring to. So that option is known to the company because we know they did it, and they simply chose not to do that here. If we look at your slide 3 from your presentation, right?
Okay.
Which is just the instructions slide.
Yeah.
Just for reference. If they had done that, on both claims, the dark green bar would be gone, right?
Yes.
Okay. And that dark green bar is more than half of the amounts in the main claim, right?
Yes. And what's the question?
Yes, I was confirming that it's more than half of the amount claimed here was the company's choice to incur.
Right. But paying doesn't exempt the penalties. Normally you get an assessment, and that assessment incorporates a penalty. You don't get a free assessment.
But it stops the running of future penalties, correct?
Well, it depends, because you pay the assessment, and then SUNAT comes with a different assessment and a different penalty. So it's not necessarily true. If I pay one assessment of SUNAT, I don't know what you save the statutory interest on that particular assessment, but doesn't save you anything else. After tomorrow, they come with a different assessment for a different reason, as it happened.
In this same time period that they chose to accrue $616 million in penalties and interest, that was the same time period in which they were making a $5.3 billion capital investment, correct?
I find they choose to accrue penalties and statutory interest. I don't think that's a proper representation of anything, because penalties are not chosen. You don't choose to pay to get assessed a penalty. You receive a penalty. You may select to delay and absorb the interest, and then you'll get that money back. But the penalty, and the penalty too, but the penalty is what you get assessed. So it's not clear that paying the assessment saves you that particular penalty. At least, that remains to be explained better, because it's not proper, your characterization.
We can agree, I assume, that you would avoid paying further interest, correct?
For avoid what?
Paying further interest.
You may save on interest, yeah.
Yeah. And if you change your tax behavior, you will also avoid further assessments. And therefore avoid the penalties in those assessments, right?
Well, yeah, but why would you change your tax stories? Your tax reporting. I don't. That assumes a lot.
One moment, please. Just a quick note about the the interest rate that you, switching back to the dividends, the interest rate that you use to bring forward the dividend distributions. If we want to look at your slides, just for reference, let's use slide 7, please.
Yes.
So you took you explained that you took the green bar, which is all the assessments. You adjusted that for tax savings associated with having paid royalties and the like. And then I'm going to talk about the transition from the orange bar to the light blue bar. As I understand it, for this period of time, you're adjusting for time, and you applied interest at a short-term deposit rate.
From the 813 to the 819, yes, that, the assumption is that the company keeps the cash at hand until it has, as you recall, you saw that declining cash balances in one of the charts of Mrs. Guzman's, declining cash balances during that period of time, the company would not have distributed dividends, and then in 2018 you start distributing dividends. So until that date, then it will have kept the cash at hand and collecting some short-term deposit rate.
Right. And I just want to ask you about that rate.
Okay.
It's the rate specifically I'm interested in. So that rate, I looked at the Excel spreadsheet to get here, but it seems to range from like 0.5% to about 2% over this time period.
Yeah, it's a low. Right? It's a low. It comes from the deposit rate, short-term deposit rate at the time in Peru was between 0.5 and 2, I think.
Yeah, somewhere in that 1 to 2 range.
With the average, I think it was 1 and 25 or something.
So when we do the next adjustment for time value, when we take the light blue bar to the dark blue bar, now there's a very different rate being applied here, and that's the cost of equity,
Correct.
which numerically I think ranges between about 5 and 8% over the 2018 to 2022 period.
I believe you're right, yes.
Okay. So that's 2018 to 2022. That's a period in which the U.S. government can only borrow at a 1 to 2% rate, right?
I think so.
Right. And if you take something like, well, Ms. Kunzman suggests that...
Well, the short-term rates is the borrow. Long-term rates was
the U.S. T-bill rates.
Yeah, that's a very short-term.
Right.
10 years rates were higher than that, but 10 years rate were around 2% to 3%.
Right. And if we said, okay, well, this isn't the U.S. government, certainly, but this is a commercial player, so if we add a couple of percentage points to that, we get rates between, let's say, 2.4 and 4.4%. That's Ms. Kunzman's T-bill plus 2.
Well, not really, because the T-bill was much lower, but this is not what a shareholder demands from.
But it is the rate.
Hold on, from postponing dividends. That is, if I'm a shareholder in a company, and claimants and control the board, and they will demand an appropriate return, and an appropriate return is at least the cost of equity. So if for some good reason they would like to postpone dividends when the cash is available for distribution, they will demand at least to obtain that return. Now here what we have is an involuntary postponement. The dividend will come whenever the tribunal makes a determination, say in 2024. So if I have to accept a delay until 2024 of my dividend, then it should be at least the cost of equity, and that's a cost for SMCB. If SMCB voluntarily postpones dividends, then it will have to distribute that amount that we provide here, 942.4, as of 2022, and some more until 2024.
Dr. Spiller, I will ask that you focus on the question that I asked. the T-bill plus 2 rate is close to is something that we might refer to as a prime rate, something that's available in the commercial marketplace, right?
No. The
And-
T-bill is not.
I'm sorry?
The T-bill is not a
T-bill
prime
plus
rate.
2.
It could be plus 2, plus 3.
Okay, right. And what evidence do you have that anyone in the marketplace would have offered 5.5 to 8.6%
Well,
in the 2018 to 22 period?
Well, simply the cost of equity in mining. For mining
I said in the
companies.
marketplace. If somebody wants to borrow.
Sorry, this is not borrowing. Nobody's borrowing here. I'm postponing receiving a particular dividend.
But what is your
So-
evidence
so
that this
the-
rate was available as a commercial rate? Do you have any
Well,
evidence that these rates were available as a commercial rate?
What is a commercial rate for you?
Have you seen
Because
the
a commercial
treaty?
commercial rates are things that are being priced based on that rate. So, for example, I can price a loan based on a rate associated with that loan. I can price a share based on the cost of equity, the cost of capital associated with that particular company. So shares are being transacted every day, and the shares have, when you discount the cash flows of a particular company, that's how you value a share, and that is the cost of equity. So all shares are being transacted at cost of equity, different cost of equity for different industries, and cost of equity is as commercial as any other rate.
Did you investigate whether rates of 5.5% to 8.6% were commercially available to third parties in the marketplace? Or did you only calculate the cost of equity of this specific company?
Well, the cost of equity is a commercially reasonable rate in that sense too.
Did you
that-
have any proof that there is a commercially available rate of 5.5 to 8.6% in the 2018 to 22
Well, shares were being transacted at that. You are asking me, do you have proof of a loan at that rate?
Right.
Well, this is equity. This is not debt. This is equity. So if you're looking at equity, you don't apply the cost of debt. It's like if you're going to buy a loan portfolio, you are going to use the cost of debt of that particular portfolio. But if you're going to buy a company who, rather than give you debt, is going to give you equity, you discount at the cost of equity. So each cost of capital applies to whatever the asset you are valuing. So if I'm valuing debt, I use the cost of debt. If I'm valuing equity, I use the cost of equity. So when we do the cash flows to the firm, we don't use the cost of equity. We use the cost of capital of SMCV, which is the balance of equity and debt, because the company, as I show in slide 3, is a balance of, has equity and has debt. So you compute the average cost. But when you only focus on the equity, then you use the cost of capital of equity. So it is an applicable asset, applicable rate applicable rate to the appropriate instrument.
I'm really sorry to interrupt. Just pursuant to the agreement between the parties, each party had an hour and 10 minutes, which would be 40 minutes for cross, which I believe we've gone over. So we just wanted to see if the plan is for Koonsman to have a shorter direct, or we'll have the equal amount of time for cross as well.
We can discuss that in just a second. I have one question left. Thank you. Dr. Spiller, you are aware that the requirement of the treaty that is applicable in this case is that to use a, quote, commercially reasonable rate. You're aware of that treaty provision, correct?
I think that
This is just a question
There are two issues on this.
No, I don't need
I know,
an
no, but if
explanation.
you're
Are you aware of that is the applicable treaty provision?
Well, I think
That's
this
a
is,
yes or a no?
Hold on. It cannot be. Although
Yes, it is.
This, no. If I look at the chapter in which this interest at commercial and reasonable rate appears, is go up a little bit on this. Go up a bit more. Is Article 10.7, which talks about expropriation and compensation. I'm not a lawyer. I don't know if that applies or not, but to me, it means that for an expropriation claim, the compensation that you're going to apply is that. And even the Article 3 doesn't apply here. We're not looking at the fair market value of a company. We're looking at historical damages, damages that happened in the past. So this is not, this is the, to me, as an economist, this is not necessarily the article that you want to look. Maybe you
Okay.
refer me to a different article, but that's up to you.
So are you operating
two
under
guys.
a legal
I-
instruction that this is not the applicable provision?
I'm not under a particular legal instruction. I understand normally we talk about commercial rates in international arbitration, and I think that the cost of equity is the applicable rate for this particular methodology. For a different methodology, there is a different rate.
Okay, thank you. That concludes my questions, Madam President.
Any questions in redirect?
No redirect for claimant. Thank you, Madam President.
Thank you. No
So
further
can I
questions.
get a sense of where I am on time?
Yes, this
So
is
that I
what
can answer council's question?
Yes. First of all, thank you very much for your testimony. We have no additional questions, so you are released as experts in these
Thank you.
proceedings. And Marisa, could you please share with us where we stand in terms of time?
Do you
And I
want?
guess I need to know what was on this examination.
Yeah, this examination you use 48 minutes.
Okay. Council, I'm prepared to proceed on either basis. Ms. Kunzman can shorten her presentation, or you can have an extra 8 minutes, whichever you prefer.
Yeah, the extra time for cross-examination would be preferred. Thank you.
Thank you.
That we will proceed on this basis and use this moment for a 10-minute break.
you get the envious position of being the last examiner.
Keeping everybody away from having dinner and getting ready for tomorrow morning.
So let us continue now with the respondents. Quantum expert Ms. Kunzmann, welcome. And let us go right away into the declaration. Could you please read it out?
Great, yes. I'm Isabel Kunzmann, and I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Do you have your expert reports? It's RER 5 and 10 in front of you.
Yes, I do.
And I understand you will also give a presentation.
I will.
So we are looking forward to your presentation now.
Great, thank you. For the benefit of the tribunal, I provide a summary of my qualifications in this slide, which you can reference later. So as Compass Lexicon mentioned, their damages calculation contains two scenarios. One, the main claim, under which they assume that the tribunal will find that all assessments, penalties, and interest constitute a breach of the treaty and/or the stability agreement, and an alternative claim whereby the tribunal will find that not waiving all the penalties and interest, incorrectly calculating some of the assessments, and not fully reimbursing SMCV for the GEM payments constitute a breach of the treaty and/or the stability agreement. Now, both claims have two components in the calculation: historical losses and future losses or offsets. Because the offsets are higher, those become negative. In total, damages under the main claim, which I will show in red throughout the presentation, are $942.4 million US dollars, and the alternative claim, which I will show in blue, $719.9 million US dollars as of September 13th, 2022. Now, there are two items of note on damages. One, claimant is presenting damages on behalf of SMCV. And Compass Lexicon, as they have said, have only calculated damages on behalf of SMCV for both breaches. So if the tribunal decides that damages should only be calculated for Freeport, you would need to reduce damages by the dividend taxes and also by their shareholding of SMCV. The second item of note that was brought up is that the second largest shareholder of SMCV, SMM Cerro Verde, has initiated an arbitration against Peru, and if the tribunal in both cases award damages, SMM Cerro Verde would double recover. I make 7 adjustments to Compass Lexicon's damages calculations. 5 of them deal with historical losses, and 2 of them with the future losses offset. All but 1 relate to both the main and the alternative claim. The sales-based tax correction only deals with the alternative claim. Now, before I go into the details of my adjustments, I want to highlight where the areas of disagreement are with respect to each step of Compass Lexicon damages calculation. So in this schematic, I'm just showing the historical losses, which Compass Lexicon calculates in 3 steps. First, the net losses, which represent the amount that SMCV paid for the assessment, penalties, and interest, net of the GEM reimbursements, depreciation offsets, and income tax savings. They then calculate net dividends lost by adding to the net losses interest at a short-term US denominated deposit rate, which is approximately 1% annually. And because they're claiming damages on behalf of SMCV, they don't deduct the dividend tax. The assessment payment, the interest run from the various assessment payment dates to the various dividend payment dates. Now, in the third step, they calculate claimants' historical damages by adding pre-award interest to the net dividends lost at SMCV's cost of equity. So, of the areas of disagreement in the historical calculations, 3 of them deal with the net losses, which is the avoidable penalties and interest, the tax measures not allowed for damages under the treaty, and the sales-based tax correction. Then the second one deals with the timing of the but-for cash flows to be paid out as dividends. And the last disagreement is with the pre-award interest rate that Compass Lexicon uses. So my first adjustment deals with the mitigation of penalties and interest. I calculated damages based on the legal assumption that SMCV could have avoided a significant portion of the penalties and interest associated with the assessments if SMCV had followed SUNAT's methodology and paid the assessment, interest, and penalties under protest after receiving the first assessment. This adjustment reduces the main claim by 62.1% and the alternative claim by 72.4%. The calculation of these adjustment hinges on what I call the cutoff dates. And the cutoff dates represent the date SMCV received the first assessment for royalties and for each type of tax. So in total, there's 7 cutoff dates. So for royalties and taxes that were due before the cutoff date, SMCV could have paid the assessment, interest, and penalties up to the cutoff date under protest to keep additional interest from accruing on those penalties and assessments. But for the ones due after the cutoff date, the entire penalties and interest could have been avoided by filing taxes under protest using SUNAT's methodology. So in this schematic, I provide an example of the methodology I used for the royalties. On the left side of the table, it shows that for royalties, SMCV received 7 assessments. The first one they received on August 17, 2009 for the royalty period between December 2006 to December 2007. The gray bar represents that period where they paid the royalties, and the white bar surrounded by the red dotted line represents the interest and penalties accrued on the assessments. So for the first 2 assessments they received, because they had already paid those royalties by the time they received the first assessment, which means the cutoff date is August 17, 2009, they could have only avoided the interest from accruing after the cutoff date. Now for the third assessment, because the cutoff date is in between the royalty assessment period, they could have only avoided the penalties and interest for those payments that would occur after the cutoff date. Then for the last 4 assessments, they could have avoided the assessments altogether, including the penalties and the royalties, if they had paid the royalties using SUNAT's methodology that they already knew as of August 17, 2009, and doing so under protest. My adjustments are conservative in 2 respects. First, as the tax experts mentioned, I understand that after receiving the first assessment, SMCV could have understood that it should apply non-stabilized taxes and royalties to the concentrator going forward in order to avoid additional assessment penalties and interest. And second, I did not include a mitigation adjustment for the interest associated with the payment plans because I didn't have enough information to do so. Now, my second adjustment deals with the tax measures not allowed for damages under the treaty. Compass Lexicon's damages calculation does not distinguish between the two legal claims, which I refer to under the breach of the stability agreement and the breach of Article 10.5 of the treaty. I calculate damages under Article 10.5 of the treaty based on the legal assumption that the royalty assessments and not fully reimbursing SMCB for the GM payments are the only measures claimants can claim for damages. So they can only claim the royalty assessments and the interest and penalties associated with the royalty assessments, and then the GM payments, but nothing else. This adjustment reduces the main claim by 39.6% and the alternative claim by 36%. And these are standalone adjustments. The impact is a standalone impact. Now, the sales-based tax correction, which is my third adjustment, is a difference of opinion between the tax experts. All I did is just completely remove the tax corrections from Compass Lexicon calculation of the alternative claim. And it reduces the alternative claim by 3.3%. Now, for the fourth adjustment, which deals with the distribution of the but-for cash flows, Compass Lexicon assumes that the but-for cash flows would be distributed based on the dates that SMCV distributed dividends. But there is no evidence to support this assumption that they would have distributed all those but-for cash flows. And without any evidence of the dividend policy or a historical pattern of practice, I assume that the but-for cash flows would be distributed as a one-time settlement payment at the valuation date. This reduces damages by 12.1% in the main claim and 11.6% on the alternative claim. So what do I mean by no dividend policy or pattern? All companies have a dividend policy, explicitly or implicitly. Some companies will distribute a percentage of their earnings or the free cash flows to equity or some other measure every year. Other companies will distribute a fixed amount per share. Others will have, before they make the investment, project companies, an expected pattern of distribution of dividends. And other companies may choose to not distribute dividends at all for a period of time. So there is a policy, and I asked for this policy, and I didn't receive it. So as an alternative, I looked at, well, what did SMCV do historically? And there isn't any disagreement between the experts that there weren't any dividend payments between 2012 and 2017, and also no dividend payments in 2020 because of COVID. However, when the years that they did distribute dividends, SMCV didn't distribute all of the available cash that they had. For example, in 2018, as the yellow box shows, they distributed a very round amount of $200 million in dividends, and they could have distributed up to $501 million. And you've heard today from claimant's side that, well, they decided what was the cash amount they needed, and then what was left over, they could distribute at dividends. That assumes that a company will first decide the cash amount they need, and then they will decide what's left over to pay as dividends. That's not right. That's not always the case. Sometimes companies will say, we will distribute a certain amount as dividends, and whatever is left over, we'll keep it as a cushion, or there are many reasons, or we'll keep, we don't want to distribute it for tax reasons, or because of debt issues, debt covenants that they may have. There are a lot of reasons. Unfortunately, I don't know what were the reasons specific to SMCV because I didn't have their dividend distribution policy. Now, the fifth adjustment deals with the pre-award interest rate. In their first report, Compass Lexicon states, To restore SMCV to the position it would have been in but for Peru's breaches, it is necessary to add interest to the nominal cash flows, lost cash flows. SMCV's cost of equity represents such rate, as it is the minimum rate of return that SMCV's equity holders require to voluntarily invest or retain cash flows in SMCV. Therefore, it reflects the cost SMCV bears by delaying its equity distributions due to Peru's breaches. However, Compass Lexicon ignores relevant provisions of the TPA, which provides for an interest at a commercially reasonable rate. So what claimant and or SMCV would have done is not relevant given the TPA's instruction to calculate interest using a commercially reasonable interest rate. Now, even if one were to ignore the TPA's instruction, Compass Lexicon, as I mentioned here, is comparing the but-for and the actual scenario, right, when it comes to damages. So in order to show that in the but-for scenario, SMCV would have earned that cost of equity, they have to present evidence that claimant had the opportunity to invest in a project that earned SMCV's cost of equity during the relevant period. And even if such project existed, they would have to demonstrate that the measures prevented claimant from raising capital to invest in said project. Now, the issue of the cost of equity that was discussed earlier relating to whether it's a commercially available rate or not, the cost of equity represents the average return investors expect from investments in the common shares of companies over a multi-decade period. It is a very long-term rate, and it is an expectation. So using SMCV's cost of equity as a pre-award interest rate assumes that very long-term rates of return can be earned over very short periods of time. Over a short period of time, companies may or may not earn their cost of equity. And in general, companies hope to earn their cost of equity, but they may or may not. Finally, there is no evidence that claimant had reinvested or was reinvesting any capital back into SMCV. And Compass Lexicon assumption that SMCV would hold the but-for cash flows in short-term deposits before distributed them as dividends implicitly assumes that SMCV would not have reinvested the but-for cash flows into the project or started additional projects. I also wanted to note that Compass Lexicon damages calculation assumes that the amounts that would be paid in dividend taxes would be accruing interest at the cost of equity. We didn't make an adjustment for this because all of our other adjustments negate this adjustment, but it is also something that the tribunal should consider. Based on the relevant interest rate language on the treaty, I consider the 1-year U.S. Treasury bill plus 2% compounded annually a commercially reasonable rate to calculate pre-award interest. Using this rate reduces the main claim damages by 7.5% and the alternative claim damages by 7.2%. Now, Compass Lexicon provides alternative pre-award interest, such as the weighted average cost of capital and Peru's cost of debt. I won't repeat the reasons again, but the same reasons apply to those rates as the ones that apply to the cost of equity. Now, with SUNAT's reimbursement rates for excess payments, Compass Lexicon is assuming that that rate would apply to all of the assessment, interest, and penalties. But my understanding is that that rate would only apply to payments, would not apply to payments of avoidable assessments, because it assumes that those avoidable assessment penalties and interest are not excess payments. Also, for both avoidable and unavoidable assessments, the reimbursement rate doesn't apply to interest. My understanding is that. Now, for future losses, I provide a similar schematic as I did for historical losses. In total, Compass Lexicon calculates expected net offsets of 12.23 million negative million US dollars, which are made up of outstanding liabilities and depreciation offsets. Compass Lexicon assumes that the outstanding liabilities will be paid as of the valuation date, and the depreciation offsets will happen between 2023 and 2027. Like they did for the historical losses, they bring forward those offsets using a short-term interest rate, and then on the third step, they discount them back to the valuation date using SMCV's cost of equity. Now, the areas of disagreement here are with the outstanding liabilities and the discount rate used. These are small adjustments. With the outstanding liabilities, on their first report, they assumed, Compass Lexicon assumed that they would have been paid as of the valuation date. But what we found is that when they submitted the second report, there were still 33.2 million of outstanding liabilities unpaid. So in our view, because it is unclear whether those liabilities will be paid or not, they should be excluded since they have not materialized. And excluding those liabilities reduces the main claim by 2.7% and the alternative claim by 0.2%. The last adjustment just deals with the discount rate Compass Lexicon uses for the depreciation offset, and it has less than 1% impact. Now, as I have mentioned, the effect on damages of all of my adjustments are standalone, and there are a couple adjustments that are mutually exclusive. In this slide, I provide the impact of several adjustments in combination. So the adjustments combined for the treaty claim, excluding adjustments 3 and 5, reduced damages by 87.4 for the main claim and 90.4 for the alternative claim. And then for the stability agreement claim, in combination, if you exclude adjustments 2 and 5, the decrease is 69.4% and 77.3% for the main claim and alternative claim, respectively. Now, for the tribunal's reference, similar to what Compass Lexicon did, I provide a cheat sheet of what are all of the adjustments, what are the assumptions for under Compass Lexicon's calculation, and then what are the assumptions for my adjustments. And with that, I conclude my presentation.
Thank you very much. No immediate questions from the tribunal side, so we hand over to the Claimants Council for cross.
Thank you, Madam President. Hello, Ms. Kunzman. Nice to see you again.
Great to see you again. Mr. Ukabiala?
Ukabiala, yes. Okay. I apologize for cutting partially into your time, and we're very short on time. So you remember the drill from last time. I'll try to ask my questions as concisely as possible and would be very grateful if you could give as concise answers as you can. And what I think would be really helpful is to help the tribunal to identify where we actually have differences between the damages experts, because I think there are actually a lot of agreements. And so I think it would be helpful to isolate the economic issues for the tribunal. So I'd like to just go through table 3 of your report, and if we could put that up on the screen, that would be great. This is table 3 of your second report.
Thank you.
Okay, so first we have adjustment A, the mitigation adjustment. And this is by far your biggest adjustment with a 62% impact. I understand from the SMM hearing that this adjustment is based on a legal assumption and is not based on any independent economic assumption by you.
Correct.
Thank you. Next, we have adjustment B, which you call taxes not allowed for damages under the treaty. And I understand that this is also an instruction from counsel.
Correct.
And you are aware that this instruction is based on respondent's Article 22.3.1 objection to Article 10.5 claims based on penalties and interest on tax assessments, correct?
How I understand this instruction is that, and I'm going to refer to the language.
And I think you might have mentioned it in your presentation.
Yes. That under Article 10.5 of the treaty, claimant cannot claim for taxes or tax assessments or the penalties and interest associated with those tax assessments. So they can claim for royalties and the penalties and interest associated with the royalties.
Exactly. Thank you, Ms.
Okay.
Kunzman. Yeah. So you weren't asked to perform any adjustment based on the application of Article 22.3.1 to Article 10.5 claims for royalties or penalties and interest on royalties.
No.
Okay, thank you. I wanted to just make sure that I know you appreciate this, but under the main claim, as claimant has articulated it, the breaches of Article 10.5 and the stability are described as and or breaches of Article 10.5 or the stability agreement, right?
Can you repeat that question?
Right. So in the articulation of claimant's main claim, claimant alleges that the final and enforceable assessments breached the stability agreement and or
Yes, and or, yes.
the Article 10.5, right? So the tribunal need not necessarily reach the Article 22.3.1 objection if the tribunal finds a breach of the stability breaches of the stability agreement.
Your questions are starting to sound very legal to me. I'm not sure. All I know is what the damages correspond to what and how I presented it in my presentation. I'm not sure what the tribunal needs to conclude from a legal perspective or not.
Yeah, no, I'm sorry, Ms. Kunzman. Let's just go to just one more question on this. Let's just go to your second report, paragraph 7. And it says, this exclusion, Article 22.3.1, does not extend to the breach of the stability agreement, correct?
Right, and that's what we call this, what I call the stability agreement claim versus the Article 10.5 treaty claim.
Right, so you weren't intending to present any adjustments based on 22.3.1 to those claims?
Correct, no.
Okay, thank you, Ms. Kunzman. Next, we have the dividend distribution date. This is adjustment C, and this is, in fact, an economic dispute between the damages experts, correct?
Correct. Could you, yes, thank you.
And this is based on your view that but for Peru's breaches, Cerro Verde would have only paid the lost cash flows to its shareholders on the valuation date.
It is an assumption I make, not because I am certain that that's what they would have done, but because I don't have enough evidence to decide what they would have done. I picked a middle-of-the-road assumption. I could have assumed that they wouldn't distribute them until the end of the concession, which some concessions do, or that they would have distributed them over time, a certain percentage. But since I didn't have enough information, I assumed the valuation date.
I understand that. And right now, I just want to establish what the legal and economic disputes are. And so then we have the outstanding liabilities. That's also based on an economic dispute between the parties, right?
Yes.
And the sales-based tax correction is a instruction.
Yes.
And the depreciation mitigation discount rate reflects an economic dispute between the parties.
Yes.
And the pre-award interest rate reflects an economic dispute between the parties.
it reflects an economic dispute between the parties, but also it has the legal implication that that the reasonable rate mentioned, the commercially reasonable rate mentioned in the treaty is what applies.
Right. I would just want to establish that you didn't receive an instruction. Did you receive an instruction for that?
No. When I calculate damages, when I represent claimants, I look at the treaty first to see if there's a specific rate to use. And in this case, there was.
Okay, so we have 4 adjustments based on economics disputes between the damages experts, and those are outstanding liabilities, depreciation mitigation, the dividend payment date, and the pre-award interest rate.
Correct.
And again, the adjustments for the dividend payment date and the pre-award interest rate are in the alternative.
Yes.
So if the tribunal agrees with Dr. Spiller and Ms. Chavich on the dividend payment dates, the difference between the damages experts on actual economic issues is around 7.5%.
Yeah.
Okay, great. So now I'd like to continue discussing things that I think we mostly agree about. And I'm sure we'll reach a point where we may not agree, and I'll let you know. But let's talk about the dividend distribution assumptions. I think a lot of this, there's agreement. I think it's undisputed that Cerro Verde paid dividends in each year between 2018 and 2022, except 2020, right?
Right.
And in the real world, that reflects a decision by Cerro Verde's board about how much Cerro Verde needed to retain as cash in the real world.
No, I don't. I asked for the board minutes to determine what was the decision making of the board. I don't know if the board decided this is how much cash we need and we're going to pay this dividends because of that. No, they could have said, we are only going to pay up to this amount of dividends because we have, it's more advantageous for whatever reason to just do that amount, or because we have a pre-established dividend distribution policy or plan that when we first bid for the concession was what we were going to do. So I don't know if that's right. No, I don't know what they did in the actual scenario.
Right. So you refer to whatever reason that would be, and whatever reason that would be, wouldn't that be a decision about how much cash Cerro Verde needed? For whatever reason it would still be a decision about how much cash Cerro Verde needed.
No. Like I said, you don't distribute dividends just based on how much cash you need, because you can raise cash many other ways. You can hold paying suppliers, you can raise more debt. There are many ways, and dividends, when and how many dividends you distribute are based on specific policies to each company.
Right, and we'll get to the dividend policies in a moment. But once the board distributes dividends, it's made a decision about how much cash it wants to retain. Is it your testimony that does not reflect a decision by the board about how much cash it wants to retain?
It reflects a decision by how many dividends the board wants to distribute. It is a very rounded figure. So, for example, in 2018, they distributed 200 million. If they had had an extra, let's say, 7 million, I'm not sure they would have distributed 207. It's always a very round figure that they distribute. So I'm not sure if the thought process at the board level or at the within the company was, okay, how much cash do we need? Great, then what's left over? Okay, let's distribute that as dividends. No, it could have been the other way around.
Okay, so I just want to confirm first that it is your testimony that the decision by Cerro Verde's board to distribute dividends does not reflect a decision by Cerro Verde's board about how much cash it wanted to retain on those dates?
It may or it may not. I don't know. That's why I asked for those board minutes.
Okay, and just really briefly on the point you raised about the round figures, you're not testifying, are you, that Cerro Verde's board would decide not to distribute, for example, $252 million in dividends because the number is not 250 million? Wouldn't they just round down or round up?
I don't know. Like I said, I asked for the information. I didn't get it.
Okay. So, Ms. Koonsman, you keep saying that you asked for the information, but you have in fact reviewed Cerro Verde's dividend policy, right? That's the document titled Dividend Policy. That's Claimant's Exhibit CE 934.
Yes, and while the document is titled Dividend Policy, it does not contain the actual dividend policy of SM Cerro Verde. It just contains what Cerro Verde can do, not what they were doing or what their policy was.
And just the document is called Dividend Policy, right?
Yes, like I said, that's the title, yeah.
And you've also reviewed the I'm sorry, first, that policy doesn't place any limitation on Cerro Verde's ability to distribute dividends that would have been applicable in the but-for, does it?
I heard that there was some dispute on that, on whether the tax assessments constituted obligations or not. So.
Did you identify any economic reason?
No, they could have distributed the dividends.
And you also.
Well, let me clarify that. They could have distributed dividends, but like I said, I have not reviewed the policy, and there are some financial obligations that may preclude them to distribute more dividends than what they distributed.
But we're just talking about the dividend policy right now, Ms. Koonsman. Did you identify anything in that dividend policy that would have prevented Cerro Verde from distributing the but-for cash flows as dividends in the but-for scenario?
I did not, but this document would not be sufficient to make that determination.
Okay. And you also reviewed Cerro Verde's bylaws, right?
Yes, I did.
Okay.
Yeah.
And for the record, that's tab 9, Claimant's Exhibit 480. And the bylaws also don't contain any restriction on Cerro Verde's ability to have distributed the but-for cash flows on the dividend distribution dates in the but-for, do they?
No.
Okay.
But there are, like I said, there are other documents that could restrict.
Right, yeah. You keep saying that, and it seems that you're basing your assumption on some rule, whether formal or informal, that you haven't seen, but that you think might exist somewhere that might have required Cerro Verde to retain a certain percentage of the but-for cash flows.
It's not might. They actually retained some of their cash flows when they could have distributed more in the years in which they distributed dividends.
Right. So just to be clear, my question is, you're basing that assumption on some kind of rule or informal, practice that you haven't actually seen, right?
I'm basing my assumption on looking at the times that Cerro Verde distributed dividends and finding that they had available cash to distribute more dividends than they actually did. And that tells me, like all companies have, there is a dividend policy. And that dividend policy, for some reason, is precluding them from distributing more cash that I would expect a project company would distribute. I agree with the testimony from Compass Lexicon. It's unusual for project companies to retain cash unless they have a very specific reason.
Ms. Gunzmann, just to follow, Anna, is this a tab number 10 in paragraph 66 of your second expert report, and the numbers contained therein on which you base your conclusion?
Well, yes, well, let me see. Second expert report.
It's paragraph 66, and then on the page 24 of the English version, table 10. And it's an overview of profit, dividends, cash, and retained earnings. I think it's based on the balance sheets and income statement.
Correct.
This is the financials we look at, right?
Yes, and also table 9 and table 11. Yeah.
So thanks. I think that you've said that all companies there is a dividend policy, and that dividend policy for some reason is precluding them from distributing more cash. And you've agreed that you saw the document in the record titled dividend policy. And I believe that you also testified that, didn't you testify at the SMM hearing that you couldn't find a pattern of a specific percentage of cash that they were distributing, or of retained earnings, or of net income for that year, right? So you didn't see any kind of pattern, did you?
Right. If I had found a pattern, or if they had paid nearly all of their available cash as dividends, then I would have modeled that. But I couldn't find a pattern.
Yeah, and you think that the secret dividend policy would have had the explanation that would have brought some kind of understanding to that non-pattern?
I don't know what you mean by secret.
Well, we've established that you've reviewed the document titled dividend policy in the record, and you're referring to a secret dividend policy that you're saying has been withheld from you, right?
Again, I don't know what you mean by secret, but I asked for the dividend policy, which means what is the policy that the company follows to decide whether to distribute dividends or not, and I did not receive it.
But you received a document titled dividend policy, correct?
I did receive a document that said titled dividend policy, but it did not contain the dividend policy.
Did it not contain a policy limiting Cerro Verde's ability to distribute dividends?
If that was their policy on 2018, 2019, and 2021, they would have distributed more dividends than they did, but they did not.
Well, doesn't that policy leave the board with discretion about whether to distribute more dividends or less dividends?
Absolutely, and that's exactly what I'm trying to find out. What does the board take into account to make that decision that it is absolutely at their discretion?
But why do we have to guess about what's in a secret dividend policy? Why can't we just look at the dates on which the board actually had determined that it had as much cash as it wanted to retain?
Because you are trying to project dividends in a but-for scenario, not in the actual scenario. You do have the data for the actual scenario, but not for the but-for scenario. So that's why I'm asking for it, to figure out what assumptions I need to make to project those dividend distributions of the but-for cash flows in the but-for scenario. Typically, you can rely on the actual scenario to find a pattern or on specific documents. In this case, I couldn't.
But Ms. Kunzman, companies don't have but-for dividend policies, do they?
Companies have dividend policies that they rely on to determine dividends each year.
And you have reviewed the dividend policy in the record. That is Claimant's Exhibit CE 934.
I have reviewed a document in the record titled Dividend Policy, which does not contain the dividend policy.
Because you insist that there's a secret dividend policy.
No, that's what you say. That wasn't my answer. We can review it again if you'd like.
Okay. I think we can move on. And I'd like to discuss very briefly the outstanding liabilities. You don't dispute that Cerro Verde has paid over 97% of the outstanding liabilities, right?
Correct.
And as of September 13th, 2022, the only outstanding liabilities were PTU, right?
Yes.
Now, so we went through this last time, and we know that Cerro Verde is a publicly traded company, right?
Yes.
And so publicly traded companies have to report their liabilities, right?
Right.
And Cerro Verde reported the outstanding PTU liabilities in the 2021 financial statements, correct?
Yes, as current liabilities.
Okay, so this is where I think we agree with everything up to there, and I want to see if we can find. So you say damages are not incurred until the amounts are paid, and as you know, we say damages are incurred once there's an enforceable payment obligation. So it seems that we at least agree that Cerro Verde couldn't have incurred damages before there was an enforceable payment obligation, right?
Let's take that step by step. Repeat the first part of your question, please.
Well, I guess really the question is, do we agree that Cerro Verde couldn't have incurred damages before there was an enforceable payment obligation?
You can incur damages in the future, but you have to show that you're actually going to incur those damages with certain certainty, right? And if you're going to incur those damages in the future, you need to discount them. Compass Lexicon didn't do that. They assumed that all of the liabilities would be paid as of the valuation date, when we know for a fact today already that didn't happen. So just based on that assumption, you would at least need to model that those liabilities would be paid in the future.
But these are the PTU liabilities that Cerro Verde owes to Peru, right?
No, they owe them to the workers. Their participación de trabajadores en utilidades, so they go to the employees.
Could we go to Claimant's Exhibit 1033, page 41? And
these were not translated, right?
No, I don't think we have the translation, but I can read it into the record.
Exactly. So what you want to bring to my attention, you need to read into the record.
Yes, of course, Madam President. Representa el exceso de sueldos limitados.
Represents the excess of salaries limited in the share participation of workers to be transferred to the regional government.
The regional government. Oh. Yes, you are correct. It goes to the regional government, and it is for what I mentioned, the utility sharing mechanism for employees.
Right. So you do understand that Cerro Verde pays some amounts directly to the employees, and they pay some of the amounts directly to the government.
Right.
Right. And you do understand that Cerro Verde incurs interest on those amounts that they owe to the government, right?
I haven't been shown that. Compass Lexicon does not mention that or provide a document of that.
Well, assuming that those amounts incur interest, then Compass Lexicon would be arguably very reasonable by assuming that they're being paid on the valuation date, because if they don't make that assumption, then Cerro Verde is being compensated for interest that will be accruing in the future. They will have to project the interest that will accrue in the future.
It would depend on the interest rate that is accruing, that I haven't seen and Compass Lexicon has not shown, and the interest rate that they're using for pre-award interest. So it may or may not.
But by assuming that it's paid on the valuation date, no interest accrues in the future, right? In Dr. Spiller and Ms. Chavich's model.
They will, if the tribunal decides to just apply interest from their calculation date to the date of payment of the award, if those haven't been paid yet. So yeah, they would accrue interest. I'm not sure if the tribunal is going to ask Compass Lexicon to update their valuation model to the date of payment of the award, and if at that point those outstanding liabilities will be paid or not. But for it to not accrue interest, they would need to do that. Otherwise, it will.
Yeah, but assuming that the payments are assumed to have been made on the date of the award, by assuming that those payments are made on the date of the award, Compass Lexicon doesn't model future damages for the interest that Cerro Verde would have to pay.
They do they do implicitly in that they're asking the tribunal to use the cost of equity as a pre-award interest rate, and that those pre-award interest will run from the date that Compass Lexicon models damages to the date that the payment is made.
Okay, well, I think we do at least agree that those amounts are owed to Peru, and it seems to be your main concern is that if Cerro Verde is awarded damages for these outstanding liabilities, that there's some risk of double recovery. Is that your concern?
Yes, exactly.
But if the amounts are owed to Peru, isn't it difficult to imagine a scenario in which Peru would pay those amounts in this proceeding and not enforce those amounts against Cerro Verde in Peru?
I don't know legally what they would need to do. I don't know.
Well, wouldn't you, if it was you and you were asked to pay amounts that you could then be reimbursed for elsewhere, wouldn't you get reimbursed for them?
I would get the advice of a lawyer. I wouldn't make that decision myself.
Okay, just one more line of questioning. So I'd like to ask you a little bit about the mitigation calculations. And so you already explained how you calculate penalties, the mitigation of penalties and interest in your presentation and in your report, so I don't think we need to go through that. And we established in the last hearing that you do understand that your model is assuming that the respondent will retain the damages that the claimant suffered as a result of the respondent's breaches.
It is not up to me to determine if those represent damages or not. That's for the tribunal to decide.
Right, but have you, are you aware of whose burden it is to carry the burden on mitigation?
My assumption is that it is claimants.
Would you be surprised to know that it's the respondent's burden to carry?
No, look, this is it was an instruction. I'm not sure what the legal implications are. So I don't know if I would be surprised or not, just because it's not something that I've gone into detail with. It's not my scope.
Okay. Well, in your adjustment, you assume that Cerro Verde is only entitled to recover statutory interest that accrued before your cutoff dates.
Correct.
The dates after which you were instructed that Cerro Verde had a legal obligation to avoid incurring penalties and interest.
Right.
And you calculate the statutory interest that you think Cerro Verde is entitled to recover, the statutory interest that accrued before the cutoff dates, by assuming a daily statutory interest rate, which is the average of the statutory interest rate during the relevant time periods, right?
Yeah.
So you don't actually compute the statutory interest that that would have applied to Cerro Verde, that Cerro Verde is entitled to recover using the actual statutory interest rates at that time.
I had to make certain assumptions because of the way the model was. I presented the calculations in my first report, and Compass Lexicon made some comments, but they didn't alter the calculations. So, yeah.
So Compass Lexicon identified the error in your calculations, and you wanted them to correct it? Is that what you're saying?
They made some comments, and in order for me to implement those comments, I needed more information. Their model needed a lot more detail, which I didn't have, so I didn't implement it.
But we're just talking about the statutory interest rates that were applicable during the relevant time. Isn't that information publicly available?
It is public information, but what I don't have is how much the period in which those interests are accruing. So what part of the interest is accruing to which assessment?
But don't you have the dates on which each of the assessments were accruing interest, that began accruing interest?
Not to the detail that I would require, no.
Ms. Kunzman, doesn't Compass Lexicon's model have the dates on which every single assessment started accruing interest?
Yes, but not, the assessment contains an assessment for a broad tax period. So there are for different tax payments that occurred on different dates. So yes, we do have the assessment date, but I didn't have enough detail to calculate based on each royalty payment or each tax payment that they did incorrectly, how the interest were allocated to those specific payments. So I have the assessment as a whole, but not the individual calculations, and the interest run from each period in which the taxes should have been paid correctly. And that change, there are many of those for each assessment.
Well, Ms. Kunzman, I'm very familiar with Compass Lexicon's model. It's incredibly detailed and it's built from the ground up. And you didn't make any disputes about when the dates of the assessments in Compass Lexicon's model, which at least, would suggest that the dates were sufficient to allow you to accurately compute statutory interest, don't you think?
I made a specific comment on my report that I needed to use an allocation for that reason. So I did mention it. But I mean, go ahead, show me, nothing.
And you called that a simplifying assumption in your report, right?
Yes.
And at this SMM Cerro Verde hearing, didn't you describe that as a calculation that's not exact?
Right, it's a simplifying assumption.
And Your adjustment also uses exchange rates from the actual payment dates, right? Rather than the earlier dates that you claim those payments should have been made. Isn't that right?
Yep.
And that would also be a calculation that is not exact, right?
Correct.
And actually at the SMM hearing, I think you admitted that the calculation for the mitigation assumption you were instructed to make is really not as precise as it could have been, right?
It could have been more precise had I had better information, and it would have been higher as well if I'd had more information, because I completely dismissed the interest associated with the payment plans.
But since the respondent we can't test that because you didn't do the calculation, and since the respondent has the burden of proving mitigation, don't you think the respondent should calculate that as precisely as it can?
If the information is available, yes, but I didn't have the information available, so I couldn't do it.
Okay, Ms. Guzman. So just one last question. You do realize that if Cerro Verde had prevailed in the administrative process in Peru, it would have been refunded any overpayment, including the penalties and interest that Cerro Verde allegedly could have mitigated in this proceeding. And those amounts would have been updated at SUNAT's reimbursement rate, which we saw in Dr. Spiller and Ms. Chavich's calculations, would have resulted in higher damages than what Freeport is asking for in this proceeding.
No, because my understanding is that the reimbursement rate of interest would not have applied to the interest payments.
What's that understanding based on?
From the tax experts that have testified.
Okay, so that's just based on an instruction from the tax experts. You can't independently verify that, correct?
No.
Excuse me, so what you're saying is that reimbursement of interest are not subject to interest? So,
correct.
But that's different from applying interest to interest, which is probably a legal provision. That's a different thing.
My understanding is that you would be reimbursed the interest, but you wouldn't be reimbursed interest on interest.
That means that it's related to the provision to apply interest to interest, but that's different of reimbursement. If not, it would not have any reason to pay in advance if you would not be able to update the amounts. Say you pay interest and you recover 10 years afterwards. That's a loss.
No, so you would, and again, I'm not the right person to testify on this.
But I'm trying to understand your assumption.
My understanding is that the reimbursement interest would apply to the assessed amount and to the penalties, but not to the interest paid on those penalties and assessment. But they would get the interest they paid back.
Yeah, but say you paid an interest in the year 2010 and you recover that 10 years afterwards. Well, say you have an inflation rate of, I don't know what's the inflation rate of Peru, but that's a loss.
But when you're getting reimbursed, you're assuming that you're making excess payments. So you wouldn't be accruing all those interest on the unpaid amounts because you would have already paid it.
The problem is from the point of view of the debt or payment of interest, it's capital. It's not interest. It's capital.
Right. And you would need to run the numbers. I don't know what those numbers are. I didn't run them. But I know I've been involved in other cases in Peru where the issue of prepayment came up, and they did prepay some of their assessments in the Duke Energy Peru case. So there must be some incentive to do that.
I promise that would be my last question, so nothing further from claimant.
Any questions in redirect?
Give me just a second to consult my own notes. Just one very quick question. When you were back on talking with council about the dividend policy and about the fact that the dividend policy leaves discretion to the board, and I think at transcript reference 1703, you responded and you said, that's exactly what I'm trying to find out. What does the board take into account to make that decision? What sort of information would you have wanted to see? What would you have expected to see? What would have been helpful?
Board minutes, also an actual written policy. Some companies will have written policies. I would have wanted to look at, for example, their original models for project companies. You have models that model out right from the beginning when dividends will be paid and how much. So those would have been documents they could have sent to me.
And what sort of discussion would you have expected to see in the board minutes, for example?
The reason why they chose to pay $200 million instead of all of the cash they had available. It could have been as simple as this is what or investors are expecting, or because of some tax reasons or reinvestment reasons, this is what we should distribute and no more.
Okay. Thank you.
Thank you very much. No further questions from the tribunal. You are released as an expert in these proceedings with thanks. Thank you very much, Ms.
Thank you.
Which leads us to more or less 5:30 sharp, and now to conclude this hearing day, which is only possible thanks to the great efforts and cooperation on both sides. Thank you very much. Is there anything you wish to address before we conclude for today?
Nothing on claimant side, thank you.
Thank you.
Nothing for respondent, thank you.
Then we wish you a productive evening and looking forward to hearing your closing statements tomorrow. Yes, tomorrow will be 9 a.m. start.